Against what?
Writ of plea was dismissed on 10/10/2022.
A writ appeal was filed against which order?
See, by the order dated
Order of single judge dated 10/2/16. Yes.
order dated 10/2/2016, Lordship.
In what? Which proceeding?
Lordship, the order of eviction was passed by the Tahsildar. Order of eviction was passed by the Tahsildar.
Under OP.
That order was passed under 227.
Yes, Lordship.
Then
There
how
are
can you
filed
maintain?
writ appeal again.
Writ appeal is not maintainable.
Lordship, the writ appeal was dismissed for default on the
That we are restoring, but we will dismiss your writ appeal.
ground of non-prosecution, Lordship.
Your appeal was dismissed on the ground of non-prosecution.
Yes, Lordship.
We are restoring your writ appeal, but we are dismissing your writ appeal on the ground that it is not maintainable. You want that order later?
Yes, Lordship.
All right. This application has been filed for restoration of WA number so and so, which stood dismissed for default for non-prosecution.
Yes.
Yes, Lordship.
Stop considering the facts and circumstances as disclosed in the application for restoration, the same is allowed. Let WA number so and so be restored to its original file. Stop. Let WA further, let WA number so and so be placed before appropriate bench on October 7 within first 5 cases.
Orders item number 1, RBWP, it is 479 of 2023.
May I please invest? Yes, this is review petition. So you are seeking review because of the Supreme Court's order?
Yes, my Supreme Court, what has happened, my lord? In this case, there are some eight petitions were there. Earlier, it was before the State Administrative Tribunal. State Administrative Tribunal allowed the. Just a moment.
In notice,
Yes, my lord.
limitation and main matter both.
Yes, my lord.
Issue notice.
About batch of applications with contract by the public.
Next, same.
Both the matters are.
Item 2,
1 week, 4 weeks. Yes,
item 2, my lord, item 2. Yes, sir.
accept notice.
Item 2, I have to instruction after one, my lord, with correspondent. So there are two SLP. By command order, both are in direction for the review. And one is already dismissed by my lord. That's not the issue. Some other request.
In similar case, review has been granted, allowed that I have filed that judgment of this.
By the
Single bank, but division bank dismissed matter.
Taking into account the
Kind of issue matter.
We will see.
Not matter.
By your affidavit, we will see.
Yes, my lord. Already dismissed matter.
Second one, you accept notice on behalf of all the
Only one. No, wait, two.
only two, one notice. I
also accept notice on behalf of second order. Issue notice. Issue notice parallel. So also accept notice. Behalf of so and so. Requisites for issuance of notice to response number so and so.
No, estimate.
1 week, 4 weeks. Yes.
Item 2, one week after, my lord. Item 2, 1 week after.
No. Other parties are required to be heard or not?
Item 2, only one party, opposite party, only one opposite party. Item 2.
Only one.
Yes.
So we accepted notice.
I will accept the notice.
So both the matters will come together after 4 weeks.
Yes.
You'll be filing Gokulatama in course of the day or within a week?
By Monday, I'll
By Monday.
Do it.
I'll come now.
4 weeks.
Once I know Malad is taking the content from the value, but this is a matter Malad the petitioner is 77 years old in his charge in his life.
Your slip, mention the age. All the slips can be given.
I pray, pardon to mention, my lord, I pray for withdrawal of item number 169 of weekly list.
All
I
right,
have already filed the memo at registry on Monday,
all right.
169.
My pardon, my lord. Item 121 and 157, it became infructuous by Flux. 157, 121 and 157.
Miller item 133, 133. 133. Complete.
I'm sorry. Supplementary. Yes. Yes.
Specially urgent matter item number 1, supplemental list. CUNTC 159 of 2013.
Yes.
I'm appearing today and also filing complaints yesterday. I have complied with
Your lordship, I'm for the petitioner. They say, your lordship, that 1,58,960 was paid earlier. Date they have not indicated. So what I'm requesting my learned friend Mr. Rao.
It is there, they will supply. It is stated by Mr. Rao, learned senior counsel appearing on behalf of the Board of Secretary Education, that this order has been complied with. So stop. A compliance affidavit is being filed today, which has been taken on record.
I am giving hand over the statement.
He has handed over check
1,10,000
worth rupees 1,10,199 in favor of, issued in favor of the petitioner in full compliance of this court's order. So stop. And senior counsel appearing on behalf of the petitioner states that date of what?
date of payment, earlier payment.
Date that though it has been mentioned in the compliance affidavit that some amount was paid to the petitioner earlier, but the date of earlier payment has not been mentioned. So stop. The court expects that the date of payment earlier made to the petitioner is communicated to him by the board. The contempt prompt as in the court's opinion, considering the subsequent conduct of the contemners, no deliberate disobedience of this court's order is made out. Yes.
Revive in that event.
The contempt will never revive.
We can again have separate.
Back to repeatsal again.
Huh?
I have to go back to, supposing my lord, there is some amount left or somewhere something is there.
No, you raise the claim, if at all it's genuine, you will settle it, what is there?
We have limited jurisdiction.
Item number 2,
But the personal appearance or lawsuit director.
Personal appearance stands dispensed with.
item 2.
Yes.
Your lordship may see the last order, my lord. Memo received.
Last order date number 3, dated 6/9/24.
Yes.
Pursuant to this order, last week they paid only grade pay, but not the increment, HR and other benefits have not been given. As per that order judgment of this honorable court. All consequential benefits, only they have given only grade pay, not the increment, house rent allowance, And interim relief.
No, but what is the order?
Order, my lord, your lordship may see page 24 and 25 of the contempt application. Judgment start at page 9, 24, 25, para 12, my lord.
Page 5 of
That is paying from 9911. This honorable said that you have to pay from the 1/1/2006 to till 8/9/2011. And first they paid the, after the filing of the contempt application, they paid the, made the payment pay and DA. Thereafter, my lord, pursuant to your lordship's order, they paid the grade pay. But other benefit have not been given. But this period only 1/1/2006 to 8/9/2000.
There is no direction.
Sorry, my lord.
There is no specific direction for payment of that.
No, benefits, my lord, benefit. All the benefit given under that period.
Which page you are reading?
Page 17, my lord.
17. You are referring to page 24.
Internal page 25, sorry, my lord.
Yes,
Sorry, my lord. Judgment page 17.
yes. Please read paragraph 12. We are relying on paragraph 12.
The affected fact and circumstances, this court is of the considered view that the petitioner is entitled to get the revised pay scale rules 1998 applicable with effect from 1/1/96 till 31/12/2005 and consequential revised pay scale rules 2008 applicable with effect from 1/1/2006 till 8/9/11 as he has been already granted that benefit with effect from 9/9/11. But I am only asking for the benefit under that pay scale rules.
Mr. Counsel, you are saying that you have not been paid HRA. You have not been paid other amounts, but this
That is a
differential scale of pay for the period and the revised scale of pay.
that is that I have given that kind of revised pay scale rules, my lord.
That is already been paid. I filed the compliance affidavit. The amount is already been paid on 23rd of September 2024.
Your lordship,
Filed the affidavit.
Please find out, please inquire from your client.
And it is not.
I have paid only grade pay. Grade pay only. Last week, grade pay. Only grade pay.
That was the direction. There was no direction for payment of HRA and everything.
Well, your lordship, the direction is as per the pay scale rules, my lord. The HRA is under the rules, my lord. That I have given, my lord. Your lordship may see page 10 and Annexure 6 of the objection. Of the objection affidavit.
And he is a temporary employee, was not a permanent employee.
Judgment said that paragraph 7 has been regularized since 95.
Annexure?
Annexure 6 of the objection, my lord. Annexure 6, page 10. That the revised scale rules 1998.
See, I am making this clear that I will not go beyond the order which has been passed.
Yes, ma'am. I am not asking anything beyond that, man.
Yes,
Within the four corners of that judgment, my lord,
yes.
you lordship may see page 11. Which
Let us see the judgment again. Read it again.
In view of the aforesaid facts and circumstances, this court is of the considered view that the petitioner is entitled to get the revised pay scale rules 1998 applicable with effect from 1/1/96 till 31/12/2005 and consequential revised pay scale rules 2008 applicable with effect from 1/1/2006 till 8/9/11 as he has already been granted that benefit with effect from 9/9/11.
Yes.
So that benefit under the revised pay scale rules, it is available with regard to increment HRA. All these things are available on the revised pay scale rules, which I have given, my lord.
You file an affidavit.
Affidavit I have 5 words.
You file an affidavit that nothing is payable to him.
Yes.
All right.
Yes.
If you file an affidavit. Let an additional affidavit be filed. Let yet another additional affidavit be filed. Filed on behalf of the contemners, stating clearly that no amount is due to the petitioner over and above what has been paid to him pursuant to grant of benefit with in terms of the court's order for the period 1/1/1996 till 31/12/2005 and 1/1/2006 till 8/9/2011. Let us see against any
May play one thing else. I filed that affidavit yesterday. Well, also kindly come to paragraph 9 years. There I will explain everything which you also wanted to know. They have given me a copy just now.
Let him say, mister. Let him say, he is saying something.
It's just bring by your copy.
He has not given.
Just now. It just passed.
You see that. You make your submissions on the next week. Why are you saying? Just see and
Yes, yes.
tell us
Yes, ma'am.
what. As list this matter on next week so as to enable and counsel for the petitioner to consider the. This is additional affidavit or what? Additional affidavit. Yes, additional compliance affidavit. Next week.
No, yes, fine. Obliged.
Item number 3.
Cut off after 4 weeks. Not after 4 weeks. Yes.
Item number 4.
That's item number 4. Well, complied with lordship's order, we recall that order, that was telling, we recall that order immediately. During pendency of the interim order, if you have granted, that has been recalled by the authorities immediately. It was a mistake on their part, so they recalled that order.
Mr. L. Samantray. And counsel appearing on behalf of the petitioner has submitted that which order has been recalled?
Yes, we have now the disengaged the person in whose favor the order was passed by the collector. The grant of distribution of Satwa, that's a serial for children that was granted during pendency of the writ application in an interim order that was sanctioned in favor of a private person, that is the opposite party, which has now been recalled. He has been disengaged.
He has been
Disengaged because the honorable court said that there was so much reference because pendency of the writ petition, he has been engaged. So she said that I can file a detailed affidavit also. Of course, I've got
file an affidavit.
better results.
Yes, 2 weeks down. 2 weeks
Yes.
as requested on behalf of the petitioner, on behalf of the contemners, to file a so-called reply.
Whole matter item number 5.
Your Lordship, on behalf of Mr. N.K. Sahu, I pray that the matter may be taken up next week, Your Lordship. He had made a mention on.
As requested on behalf of the petitioner, list this matter on next week.
Your Lordship.
Next week.
Can it be sometime after vacation?
After vacation.
Right.
After holidays.
Item number 6.
Obliged.
Pardon, my lord. Item number 6. I have filed 3 content petition, 2 listed in item main list, item number 5 and 6. And here, item number 9, item number 6, another 2 matter listed with today weekly list. Item number 5 and 6. So now your lordship kindly see.
How many cases have you filed?
My lord,
How many cases have you filed?
3 cases.
Three cases, where are they? This is one. And where are the other two?
Two is item number 5, week list. Item case
Five
number
weekly.
week list 983-18 and another is 988-18. Content 88-18.
All are similar.
Similar. Arise of the same
Yes,
for the
yes.
background, say,
No,
analogous.
matter along with. So and so, 983, 988. After holidays. Yes.
So logically,
7 same years, similar ones. 7 is connected to 6 years.
7.
7 is connected to 6. That will be technical level that particular.
7 is connected to 5 or 6.
Or same year. There are 3 years, 5, 3 contents. 6 and 7 are in the supplemented list. Item of 5 in the list years. So all those 3 can be taken.
But he said there are 2 cases in the list.
No, 3 cases in the supplemented list.
your lordship can see
6 and 7 are similar. 6 and 7 are similar.
6 and 7 are similar, Mr. Counsel. Mr. Counsel, 6 and 7 are similar.
Hello. I think, oh, I'm sorry,
similar.
All right. So this case and 2 cases in the
sorry,
those cases shall be listed together. Yes.
Your lordship can see order dated 26/7/2000.
All the cases be taken up together, Mr. Counsel. All the cases shall be taken up together.
Item number 7.
Why are you worried? All the 3 cases shall be taken up together. You don't want.
Yes.
Why are you responding?
Should taken together to be convenient.
Yes.
Supplemental list item number 7.
Yes.
Item 7 will accept pursuant to the lawmaking order. That is complied in time law. Complied with this law. All right. Pursuant to the lawsuit's order, then that has been complied. What about civil? Civil we are arranging so you will then we can introduction.
Sir, I have not examined. You are actually disposing content. Let it come next week. I will examine it or movement. So,
Your petition has been. Yes.
item number 8. Wife of a deceased employee claims the area dues below.
Lordship has order dated 6/9/2024. They are partially complied. Lordship directed to comply rest of the amount. 6/9/2024.
Which order? 6/9.
6/9, yes.
6 dispose of
Yes, and we have an instruction.
Yes, sir. I'm extremely sorry. 6/9 wrongly I mentioned the dispose of, so I could not write it complete.
Question on behalf of the, while when this matter on next week. Just see whether any amount is payable.
Admit. In their counter, they admit some amount is there. All right.
Item 9.
The appellate party take the order of this level court.
All right. Yes, sir. In his case was accepting the pensionary benefits.
The fire has not received the petitioner matter.
It was process sanctioned on the 20th of June 2024.
The order is called. Yes, your lordship, may kindly see page number 11, my lord.
11 is no order.
Paragraph 5. Can I give you one?
There is nothing violent. Consider and dispose of.
In respect of that, So sanction, it has been resolved. The Honorable Court directed to file a comprehensive representation. Consider that
Mr. Council, was there any direction for payment of anything? Where is that?
where is the direction of this court to pay? This Honorable Court directed for highly comprehensive representation. That representation till date has not been disposed of. Was special to that.
No, no. No, wherever you have to initiate contempt proceeding. I'm initiating contempt proceeding.
No, I've got the instruction to file the compliance affidavit, but then also to file next week, and then I will file that affidavit.
That is disobedience of this court's order dated 8/9/2021, whereby the petitioner was asked to file a comprehensive counter affidavit, a comprehensive representation as regards his claim for promotion to claim for grant of career advancement scale as lecturer senior scale and other reliefs. Mr. L. Samantrayal and AG has submitted that the petitioner has been paid as per his entitlement all amounts other than pensionary benefits. This was stop. Learned counsel appealing on behalf of the petitioner has however submitted that till date the representation has not been disposed of. List this case 2 weeks so as to enable an AG to seek instructions and inform to seek instructions and file an affidavit stating whether this court's order which is through and so has been whether the petitioner's representation has been disposed of or not. So after your representation is disposed of, I'll not go any further.
Representation under Annex 2 of the contempt petition.
Yes, sir, they will decide.
Now, item number 10, another further arguing this contempt. Contempt next 2 weeks. Yes. I don't remember. I prefer next to that I will have been misplaced somewhere in the okay.
What was the order?
Order was really position of formation and proceeding.
Next of this representation.
But so, when find the complaints affidavit, also people also look at the as well as on April 2020 last 2. Find an affidavit, compliance affidavit.
It is there.
Yes, no.
The petitioner has alleged in the present contempt application disobedience of an order dated 26/11/2021 passed in WPC number 35541 of 2021. Operative person of which reads thus operative person taking into consideration. Compliance affidavit has been filed on behalf of the Tahsildar on behalf of the contender / Tahsildar Sadar, stating wherein that in compliance of this court's order, petitioner's representation was considered and directions were issued to the revenue inspector to investigate the matter. Stop. Later, based on the report of the revenue inspector, the inspector had issued Form G as per Section 3, Bracket 1 of the OPLE Rules 1985 to the importers. Stop. Next, since the opposite parties, there is reference to further action taken on the petitioner's representation. Stop. Since the petitioner's representation, since after having considered petitioner's representation, the contenders appear to have acted in the light of this court's order, which was passed on the same day when the petition was taken up, without giving the encroacher and opportunity, without giving parties an opportunity of hearing. In my opinion, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is dropped. Yes.
Item 11. Let's see, item number 11 and 12 on the other, that means, sir, no instruction.
No instruction. No,
No instruction. I have no instruction.
no instruction.
11 and 12.
11 and 12.
Item 30. Attorney also order dated 13/7/2020 has not been complied with. Please wait for us. 13 complied with.
Complied with. Complied.
Item 15.
Complied. Complied with.
Item 16.
16 order in 36/22. That has not been complied with.
Complied with. No.
No problem.
Item 17.
Lordship, so cause notice, so cause reply not received, your lordship. Order dated 7/2/2020 do not comply.
What was the order?
Your lordship at annexure 1.
What was the eviction?
Your lordship, your lordship not clearly audible to me.
And in this case, all the letters of rehabilitation assistance scheme were challenged because the spread up. Subsequently, government has challenged that before the honorable appeals court, I take instruction whether this order has been challenged or not. Well, let's on this matter next week. I will question on behalf of. Continuance, list this matter on 2 weeks. Yes, on 18.
Let's move.
Item 18 complied with. Complied with. Item 19. Complied with. Item 20. Complied with. 21.
21 minutes to continue time with documents. The order against which I have filed contempt has been deleted that much.
Only.
Wait.
Infected.
Item 22.
Complied with.
Item number 22. Already complied.
Complied.
Item number 24.
24 मतलब SLP to me नहीं. SLP.
Item 25.
Complied with. Complied with.
Item 26.
Complied with. So only the 5 matter. And we got the on to 26. 26. I. 20. So you can challenge that order for us. From 27. I don't know, 28. That's just I got the accounting launching line. That I got 27, you give 30. 28 you got 20. That is discover. The absolute discover 25 there. 20 grams in time. 28 means sitting to time. Proceeding instructions. 28 I will request to 2 weeks. Item 29 grams in time. 29 yes. 2 weeks. Item of 30. But I continue to complain as for that state, but I have high objection. We'll also have a glance at seeks examine. We seek instructions. Very small. Thereafter, the content has been filed because this one because of the depiction of the criminal matter. And their account of the content fiction also direction has been made to comply the order matter. Challenge with that judicial order matter. Let me judicial order. Let us see the order passed by the tribunal. Your violation of the tribunal's order. Where is the order? At page 16 of content petition. Yes. The order starts from happy mailer, but operating parties are far up high mailer. Yes. The considering yes. Considering rival pleading of the party not disputed that the document in the advertisement history by the Staff Selection Commission on 16/1998, the applicants were selected as women stenographer, and their names appear on the select list by Annexure 1, letter A, 1999. The name was sponsor to respondent number 3, DG and IG of police for issuance of appointment order, but no appointment order could be issued. Election pending against the selection of a junior stenographer, and only after disposal of the litigation, the appointment orders were issued on 19/11/2010 at the Annexure 6. It appears that names of other kinds sponsor to other departments have been covered with the appointment order. I cannot read it. Page 16, we have fair copy. Page 16, I cannot read. I copy. Difficult to read.
So have you given him the UPF scheme and included them under OCS pension rules? Have you done?
No, but during not here we have the right scope of affidavit. Your lordship may kindly see page 12 is the first title of the order passed by the tribunal. Along with the petitioner, several other original applications were disposed of by virtue of a common model. Now, in case of one Kalandu Charana Beda, he approved this honorable court by filing subsequently a writ petition. That writ petition was disposed of with a direction to consider the representation. That was considered and rejected. And the contempt filed by that Kalandu Charana Beda was subsequently dropped by this honorable court. Similar ways, in the case of another person, Pipasin Bipanda, and there also the writ petition was filed, representation considered rejected, and subsequently contempt has been dropped. They were all part of the affidavit I have.
Mr. There is a positive direction.
Yes.
So you will have to comply with that.
So what they have done in this affidavit, they have, in fact, since they have rejected in case of two others, they have.
They will also.
I will have.
I'll say so you will have to carry out.
Yes. I'll file a press
I let my grant as a list for obedience of an order passed by the Odisha Administrative Tribunal, operative portion of which reads paragraph 5. Page 16. Paragraph 5. Stop. Now, after having so-called reply has been filed on behalf of the containers, which prima facie does not appear to be satisfactory. So, by way of indulgence, 4 weeks' time is allowed for the containers to file an additional so-called reply stating as to whether they intend to comply with the enforcing order or not. So, non-compliance of the said order in its letter and spirit shall be viewed seriously. Prior to filing the supplement given to me, that will yes, 4 years. I will have to
Writ appeal is pending, madam. Writ appeal number 1041 of 2024.
and the method regarding the pension method, provisional pension method. But because we have challenged that we will have to be heard, no? One solution method, the petition disposal 25/11/2022 method. Writ appeal was filed my lord 22/5/2024 method. Whether delay has been controlled, no, that's not this order is direction is that, my lord. The extension of the provisional pension shall be paid, my lord. The petitioner is retired employed, my lord. Is going to the finance side, that's it. Only the highlight is left of the matter, my lord. Why the condonation application has not been taken up? With the filing and the select of the matter. Instruction is not available. So it's just all the cases they will file condonation applications in later fees. At least you should make a mention so that the condonation is decided this way or that way. 32. Pursuant to the direction of this honorable court, in the encroachment case, reports were called for, and finally it was found that there is no encroachment on the government land. Government land is vacated, and the lease encroachment case has been dropped. The petitioner there is no representation on behalf of the petitioner. The petitioner has alleged disobedience of an order of this court dated 4/12/2023, passed in WPC number 3891 of 2023. Whereby the petition was disposed of with a direction to the opposite party number 4 of the writ petition to ensure the removal of encroachment with the deployment of police force. Alleged encroachment. So the writ application was filed, the order dated 4/12/2023 was passed on the very day when the writ petition was taken up without giving any opportunity to the persons who had allegedly encroached the public land, government land. So it is stated by learned AGA that an inquiry was conducted into by whom? By the RI Russellpur, by the Revenue Inspector Russellpur, pursuant to this court's order dated 4/12/2023, and it was found that there was no encroachment on the government land. Such way of the matter, no case of disobedience of this court's order is made out. This application is accordingly dismissed. Item 33.
Last time, well, honest counsel at 2-3, I have not such things. So grant me week's time, I'll
But need further time allowed for the AG to seek instruction.
last result, the tendency is long.
Since when?
On this occasion, they have taken 3 to 4 times, madam.
No, since your matter is pending since when? So you are saying your matter is pending since long. Your matter is pending since when?
It was filed in the month of March, madam.
Month of March. Of which year?
24, madam.
24.
Only to take inspection, they have taken time out 3 years, madam. Right.
So you get your fee for every appearance or for
Madam. Yeah, at a time.
you are not required to disclose. You could have said that I will not disclose. All right. Yes. 34.
Oblige me. Estimate credit the last order, my lord, 20th September.
Yes.
Directed to file social appeal.
Yes. What have you done?
Here, my lord, pursuant to the order passed by the honorable court,
18/7/2020.
your lordship may kindly see the operating portion of the order. That is at page 3. Page internal page 3, page 10 of the contempt petition. Having heard the learned counsel appearing for the parties and taking into account the materials available on record, this court finds that even though the petitioner has retired from service, but the OP number 1, after due consideration of his claim, allowed the benefit of grade pay so in the shape of third RSP. After extending such benefits, then the OP number 1 submitted the pension papers of the petition for revision of the pension as found from Annexure 5, objected to grant such grade pay of 5,400 in favor of the petitioner. It is found that on receipt of the communication, OP number 2, OP number 1, without issuing any papers and without following the principle of natural justice, recall the order that it so and so. Then, so the order is very clear. In pursuant to the order, they constituted a screening committee. That is the instruction I have received. And the compliance reads that in due compliance to the above said order of the Honorable Court, the OP number 1 has examined the third RSCP in favor of the petitioner, and it is found that the petitioner is entitled to the grade pay of 4,200 instead of 4,600 or instead of rupees 4,600 or rupees 4,400 as per the point number 6 of the Finance Department circular dated so and so. 5 year. Last occasion also the same discussion was made. But thereafter the lawsuit directed. He also forgets. Right. Yes. Mr. Counsel. But I am not filing. I will file. By way of last indulgence, 2 weeks further time is allowed for. If no so-called reply is filed by the next date, the court shall consider imposing cost and initiation of contempt proceeding against the contemners. Finally, Google it. Finally, running on just 2 weeks. Item 35. 35 is also back to a week's time. A week's time. A week's time. 36. Yeah, 36. Yes, 36 months, the instruction I have received. In fact, on inquiry by the proceeding, no encroachment found. The question of unauthorized occupation for more than 30 years was not found to be correct by the, that is the instruction I have received. The petitioner had filed. Petitioner alleges disobedience of an order dated 22/2/2023, passed in WPC number 2467 of 2024, whereby 24, whereby the writ petition was disposed of with a direction to visit party number 4, therein to consider the petitioner's grievance relating to removal of encroachment. Removal of encroachment. When counsel appearing on behalf of when AG representing the contemners has submitted that upon inquiry it has been found that there is no encroachment as was alleged in the writ petition. Stop. In view of the matter, since the order of this court dated 22/2/2024 was passed on the very first day when the writ petition was taken up without issuing notice to the released contemners on a new case of deliberate disobedience of this court. Disobedience of the said or order of the court and be said to be made out. Contempt proceeding is out. Yes, 37. 37. The case of the petitioner was disposed of in terms of the judgment passed in case of Akshay Kumar Naik. That Akshay Kumar Naik case, state had preferred SLP before the Honorable Apex Court. Now the Honorable Apex Court will achievement kindly see the Honorable Apex Court has set aside the order passed in the writ appeal because it was only on the ground of delay. The Honorable Apex Court has set aside and remanded back the matter. The petitioner has alleged disobedience of the petitioner has alleged disobedience of an order of this court dated 28/9/2022, passed in WPC number 11357 of 2021, which was disposed of in the light of
a decision of this court in case of decision of this court dated 4/8/2022, passed in WPC number 5480 of 2021, bracketed Akshay Kumar Nayak versus State of Odisha. Learned AG has brought to my notice an order of this court dated 13/9/2024, whereby the said decision in case of Akshay Kumar Nayak has been set aside and the matter has been remitted back to the High Court.
My lord, the release of the number has been indicated in the Honorable Apex Court order. That last page you will also kindly see. The root appeal number is 1780/2022 and the judgment appeal 11/2023. Same, my lord. My lord has referred to the single bench order of Akshay Kumar Nayak. This is the division bench order which was challenged before the Honorable Apex Court and set aside.
So in such way of the matter, comma, in the court's opinion, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is dropped. 38.
Item 39. 39 was also kindly see a lawsuit for last occasion we had to take instruction to the State Council. To the
Item 33, the Lordship may kindly see the case of the petitioner were disposed of along with a batch of case minor. In case of Lordship batch of case WPC 40936 of 2023. In one of the case, Lori had to, we have already referred the writ appeal. And in some other cases on both, my instruction, we have filed writ appeal. So, your Lordship may.
You will be filing the against affidavit.
Then file the affidavit.
File the affidavit.
Will file the affidavit.
File the affidavit in this case.
Not yet filed. Will file our.
2 weeks. Yes, you must be adding the 2 weeks. But in the meantime, you will assist permission, I make some submission. In the meantime, the past base cases, the 5 cases, madam. That is, when we see 396 of after the judgment, my lord, some persons are left out, not filing case before this honorable court. And after the judgment, they are filing case. This honorable court dispose of the applications. Basing upon this judgment, my lord, consider the case of the petitioners in the judgment passed in the resolution, my lord. Thereafter, when implementing that order, in this case, the government, that honor of that in time to go 24. But in this case, the not I have
some contempt matter pending. The question is that you were granted relief based on some decision. And that decision has been challenged.
Yes.
Is it a fact?
No, the question of the high applications, the common judgment was passed. Some applicants are left or not highly, they're not going when the time of the judgment, after the judgment, they the application consider their case. The single judge, dispose of their application, they see upon this judgment. After the order, they have implemented the application. Now they find the judgment.
Forty also same line.
Same to 45 election.
45 it is said.
40 and 40, item 40, 39 to 45. 39 to 45. 39 to 45. Yes.
Item 46.
46 complied election. 56, will also last for a time of the answer. So they have, they are sort of stating that it is time of the. So the sort of there is not, the paragraph 8, that in view of the fact that the experiment in the official basis to allow at least 8 time to upload paragraph. And the 6, 9, 24. And you also granted time input. But it has not yet been completed. Yeah, much. All the 12 matters have been coming.
What are you ordering?
Paragraph 7. As such person who owns benefit has an extent some of their own and some of the present business this has been done, madam.
Benefit has been accepted, it's extended.
Extended, your lordship, in all the 12 matters. We have the compliance affidavit, your lordship, is filing.
Yes, you can say,
Order copy.
You have the order, Mr.
Extended.
It has been extended and the order has been complied with, do the order. Madam.
All the collected cases.
Item 47.
Your lordship, item 46, the sub, and according to the sub items, your lordship.
So I can.
The rest of the sub items, your lordship, except the first item. If I need to serve with the copy, I'll give it. Your lordship, I need to serve with the copy.
this order only the rejection order, where the direction has been to extend the benefit of the, it is cannot. So, justice can there this order,
I have seen the order, I have seen everything. We went to court without giving them an opportunity. You file a writ petition, your writ petition is taken up the very next day, and order is passed, that you extend the benefit in terms of the order passed in some other case. If the court had directed to extend the benefit, why have they not extended the benefit? And therefore, the contempt, why have they not extended the benefit? What is the logic given? They have to say,
You can file all the compliance affidavit, your lordship. With regard to all the cases.
what is the decision?
Decision, your lordship, you've taken, you've given me all the compliance affidavit, you're supposed to be filing it today, your lordship, I'll sign it.
You understand whether you have extended the benefit or you have declined to extend the benefit on any ground.
You've extended it.
Because in all such applications, you need to file review. Because how can Mr. Counsel, why are you saying? Let me see the order.
Sir.
Madam, you are looking.
Lordship, the last paragraph says that the prayer has been rejected, your lordship.
What I can do, I can direct them to recall the decision which they have taken. Well, according to
discuss it, no, issue reports are on the case. Now they have given that.
yes, whether they have in compliance or not. See.
Many of the petitioners, they have rejected the claim, and 10 petitioners are writing 10 petitions.
So first if they have complained that they have stated. Yes.
And the ones that have been rejected, liberty will have.
Then cases that are elected, but the
Stand for election, where this case, what's going to election can happen. This case, no election can see rejection. Rejection law. And it's where you want me to see the reproduction or the independent content question law. This is state law. But now we have started house only. And the background
Let me see where is the orders.
yes. Mr. Council, the first order. The detail page 9, 21, 8 to 22.
Annexure,
Annexure, that is annexure 1. Content petition, annexure page 9. Which is the order? The petition of application seeking for a election to provide the house into the Regularization. Which order election directed that my combined case may be considered. Thereafter, within consider, I find a content petition. In content petition, is simply the first actually, that is
council, I will not see any order other than the order passed in the writ proceeding.
yes.
Come to the order passed in the writ proceeding.
Yes, yes. Annexure 1.
Yes.
Yes. That is the so that I think that directed form getting church 18 to 23. Yes.
Council receive the order.
Yes.
Whether your representation has been disposed of or not. Yes or no? I will not be. I told you in the very beginning that you in this present application, you allege disobedience of this court order passed in the writ proceeding. Yes. In the contempt proceeding, this order cannot be expired. If you want an order observation of this court, I am ready to give an observation. We have to see whether this order has been implemented or not. That's all. Whether can I dissolve it or not? That is it. It's just a minute.
Signing the gift.
48.
It's a good
Council, you should get rid of this practice of getting your representation, direction for disposal of representation. It has affected your approach. You have you could contain the court to decide to adjudicate upon. But on doing that, where is the question? But my name is shown that since next 48.
Where is with us? I mean, the judgment will back where the son of the body. By the unnecessary one, judgment has been back where the son of the
Where is that?
unnecessary one, page 9.
Annexure 1 is the order.
Yes,
Yes, where is the order?
page 9. Yes, you can go ahead. Page 9 is the judgment. And the authority person is with the
Yes. Yes. Who saw the Which university? Yes, local university. Yes. 1 year, 4 years. Yes, order item 49. Item 50.
Your lordship, I see 1 month time, your lordship, to
1 month.
for eviction, your lordship. Because of the flat situation there, the eviction was in.
As requested. 6 weeks. Yes. Closed.
Roll back to item number 1.
Order of the surveillance page of 2015. Let's kindly see page 20. Page 20, also can see. Subpara page 22. Accordingly, the petitioners in these cases also will be entitled for minimum pay scale on the basis of their experience 98 and 2008, which effect will be 196 and 2006 respectively. This part has been answered in favor of the petitioners. The lordship will kindly see the next page, page 27, para 27. Hence, the authorities are directed to release the differential amount as indicated above within the reasonable period of within 6 months from the date of receipt. So,
I find a review.
I review.
Review is also there. That is
review. Admission, nothing else.
Only the accept notice. Do you accept notice?
That is, the notice says, there is a delay, some of that in review petition, that is the discuss for termination of delay. Election is that review. That delay has not been done, so election notice in that delay petition or
Whether you are accepting it or not.
discuss for the petitioners. I will take instruction to accept that review petition notice.
Accept notice. In the criminal contempt application, the petitioner has alleged disobedience of an order of this court dated 1/12/2015. Passed in WCC number 18254 of 2012. It is notable. It is worthwhile mentioning. A review application has been filed on behalf of the state of Orissa, seeking review of the said order by RUPET 266 of 2016 with an application for condonation of delay, which has condonation of delay. When counsel appearing on behalf of the petitioner accepts notice of the review petition and with limitation petition. Stop. List this matter on. List this the contempt application along with the review application on. How much time will it take? 2 weeks. So as to enable counsel for the petitioner in contempt suing PC 1345 of 2016 and opposite party in RVP, opposite party to file reply if so required. You have the copies of that review petition and that copy of the application, the review and review application and the limitation application be served upon then counsel. What is your name?
That is Senapati.
Mr. S. Senapati. By today?
Yes, sir. Monday was
By Monday.
yes.
Item number 2.
Last year, glance order, page 5 of my contempt petition, answer 1, running page 6 now.
Let me see the order. Order of this court.
Yeah, we do tell.
Yes. Order of this court, page 5 of my contempt petition.
Five.
Running page 6.
Running page 6.
Yes, ma'am. Considering the submission of law and counsel for the applicant and non-standing counsel, for the grievance of the applicant for regular and completion of 6 years of service has not been pending active consideration of respondent number 3. The disposed with the direction to respondent number 1, 2, and 3 to take appropriate action for regulation of services of the applicant and issue appointment order following the regulation of the government that is 17/2013 has done in the case of similarly situated paramedical staff such as multi-purpose health worker of their district without other communicated source of such action be taken in increase.
Yes, sir.
Well, I find the compliance of the book. Now, kindly clarity is.
Have you given him?
Yes, ma'am. Wait, for the director will explain the kindly say order number 16. Madam.
Just a minute, Mr. Paragraph?
Page 7 for a moment.
Yes.
Now I have page 7. Opposite part number 7.
Here.
Who is the petitioner here? Now this case was filed in 2009. Decided on 26/8/2015. In this case, matter, he got appointment of court by the government. Now we kindly say. This was published in the next step and that was passed. Now we kindly come to page 16, please. Paragraph 11, Madam President. In view of the discussion, the procedure adopted by the selection committee for selecting the candidate the selection committee can only make on the basis of marks secured in the form of examination. So the applicant has secured 79.12 marks in the form of examination and the opponent here has secured 72.53 marks. The applicant is eligible to be selected and consequently the selection of the 27 is bad and liable to be crossed. Now, in paragraph 12, while concluding this president said, we will continue in ad hoc posting and in a vacancy available. That we have done now. He has continued to do. In my respective submission before this honorable court, he has no action for contempt. And if this order is to be implemented now, we cannot implement the subsequent order. In the next case, he files a case and if nothing has happened, he goes for regulation and the regulation order was passed.
But you should have sought review on the order or you should have challenged the order.
Well, this first order was challenged before this honorable court. What is this?
Second order. Because in the second order, there was a direction for regularization despite the earlier order passed by the tribunal. You could have brought to the notice, even today you can file review application, we can review, no, you have to challenge that. Had you disclosed in the subsequent proceeding that this order was passed?
Yes, something like that. Regarding that. Paragraph 10, had the order has been passed. And concluding, we will make that respondent number 7 has already put into 6 to 7 years service and have been no scope for him to apply for any other government job, which is likely to suffer for the wrong procedure adopted by the government operating. Therefore, in our consideration, instead of paying him out of job on the basis of record of
I will see later.
yes, what we say.
Okay.
I mean, how do you get this?
It will come after 4 days.
Yes, yes.
Item number 3.
Appealing on behalf of Mr. For this time itself for filing this compliance certificate. Last order, I have a glance. Last order, 1974. What is it? 1974.
Yes, it's a case for initiation of contempt proceeding.
Yes, already I have received the instruction, but I have complied this, I have filed this compliance certificate waiting for this, my lord. Already process is pending with the legal department.
At the law fair. Okay.
This case I have application for the consent law that my filing is 2024. Suppose not
Yes,
and for the petitioner, my lord, here, I received a copy of the objection.
if you have been compliant with them.
The reason, but that reason is not as it is because there is suppression of material fact. I want to give a reply to this.
No, you can channel that.
My lord, the annexure one is a disputed one.
Let me see the order.
My lord. The auction is value falls to page 15.
Order is on page 15.
Operating party.
Operating party, yes.
This is the regulation for 56 proceeding. My lord,
Just a minute.
nobody has all the order. The proceeding will be taken as re-execution in considering in the period of 8 months. But I have a very opportunity to consultants. Since the petition is ongoing stay of since 2003, there shall be status quo in respect of this disputed property indemnity in this case till first decision is taken by the challenge. My lord, during this status quo order, they had violated this order and encroachment land and making a construction. My lord.
The
And that is my sole allegation, my lord.
the petitioner has raised his obedience of this court's order dated 5/7/2017, passed in WPC number 4367 of 2003. So-called affidavit has been filed on behalf of the contemners, wherein it has been specifically stated that stated that
So if EIP, what is this? My lord, that is the original application, my lord. Petitioner will not be happy. That case order has already been challenged and let me explain, my lord. That order has already challenged before the court. This court has directed the petitioner to prepare an appeal. In the appeal, this against me that during the pendency of the appeal, there is a stay order, my lord, injunction order. And yes, my lord, injunction order is there. And during the after the rejection of my appeal, I immediately come to this election, and this court has directed under annexure, my lord. Answer 1, my lord, and 11 question is page 20. That is continuing the same convention order since 2003. So it shall be there shall be a status quo. And my lord, if your lordship kindly see the police report that is under annexure 2, my lord, kindly see.
you are challenging an interim order. Sorry, you are alleging violation of an interim order.
Yes, my lord. That is not exactly in the final order. They have given me the status quo. They have given me status quo. And my lord, kindly see the report that is on page, my lord, Annexure 2, my lord, page 23. I'd like to prefer, my lord. And where I have lodged the complaint, my lord. I have lodged the complaint, my lord. My lord, on paying 2018, my lord, we have to see whether some proceeding is pending. My lord, where is that pending? My lord, whether any proceeding is pending anywhere. Yes, but yes, my lord. Where? That is before the contempt application, whether there is any proceeding pending. Yes, that is again the appeal has been limited back to the appellate authority, my lord. And said the additional question has to be corrected. And the confirmation of status quo order, my lord. There is no revision of the stay, my lord. Since my appellate code to this code, there is a status continuation of the status quo order, my lord. And even the ending of the status quo order, how could we encroach upon my land and making an extension? Who decide that? Who will encroach upon? I don't know. Procedure under regulation 1956. I am the land that fellow is not in position, my lord. That is in our position. My lord, can you see the photo side?
This is a disputed question of fact. Who will decide it in contempt proceeding?
My lord, my point is that who is encroach upon the land, my lord.
According to encroacher, according to he is not an encroacher.
My lord, can we say, my lord, the police 23, my lord, the police report, what the police report has said?
Where is the matter pending?
Additional district magistrate correct.
Why is such
My lord, at least let me, so this what I want to access separation, my lord. I don't have objection, my lord.
What the court will decide? If the court decides on the contempt application, then what will the court decide? Tell me. And what will be the effect of the finding of this court in case something is decided on the case which is pending? Now, what is to be decided by them will be decided by the present contempt application. The petitioner has alleged disobedience of an order of this court dated an interim order of this court. No, status quo. An order of this court dated 5/7/2017, passed in WPC number 4367 of 2003. Stop. It is the petitioner's case that the order of status quo has been violated by the contender. Opposite party member? Number one. Stop. It is the case of opposite party number one, on the other hand, that he is in rightful possession over the land in question and land in question. Stop. The dispute between the parties is yet to be decided by the learned additional district magistrate Korapur in OSA TIP number 18 of 2002. Stop. Next, in such view of the matter, in the court's opinion, no fruitful purpose will be served by entertaining the present contempt application, which revolves around allegation and counter allegation as regards physical possession over the land in question. Stop. Such disputed question of fact, in the background of nature of dispute between the parties may not be gone into in a contempt proceeding. Stop. The contempt proceeding is dropped accordingly. Stop. I will make it clear that any observation made in the present order shall not prejudice either of the parties in the proceeding which is pending before the edition.
Item number 7.
Last provision, it comes here directed to take instructions. So matrimonial hearing order is first to conclude the clearly procedural. That is enforcement case number 85 of 2014 order. Order has prepared but para two of my content application. Para two 2016. The operating person is last forever, considering the innermost nature of the prayer made the petitioner. This petition is disclosure with the direction to the
What is the stage of encroachment case?
Yes, in fact, the notice was issued and the so-called appealing the also kind of looked I so-called was filed on years 19. The to the looks like the friend. Yes, they also look at the notice was issued to all parties, not they did not appear before the Tahsildar and then some of the respondent opposite parties, they filed copies of civil suit to the pending petition with respect of that name.
Mr. Counsel, whether in your petition, the persons who had encroached upon the land, they were imputed parties.
Yes, they are imputed by
They were noticed.
yes, subsequently,
They were noticed.
yes, they appeared, they filed an application for modification of the order that was considered, and this order was again directed them to approach the appropriate authority. And a date was fixed, those parties were directed to appear there.
But yes, what happened? It's pending since 2014.
2017, I given the last order. The case was put today for hearing the order. The one parties are present. The first party, the night of the petitioner. Second, that second parties are possibly involved in the dispute for which sample the interest of the villagers. The first party submitted a petition on behalf of the villagers of offender. The villagers of Ellen submitted in his application that the claim of the third parties are baseless and also stated that an encroachment case is being initiated on the appeal act for consideration clause number 650-674 by the indication number 85/2014. Which is the indictment of 10, clause number 653. These three clauses are under consideration by the offender, which has been recorded in the name of the state. So the third party have no bona fide title and substances. But here the first parties also submitted that after permanently residing for the second party is legally included hospital land by land grabbing. Second party, when the Janaki Naik submitted a certified copy of CS number 373 of 2014. Filed in the court of the non-civil state, submitted that the disputed land is recorded in the state, but the same belongs to the plaintiff number one, except to the ancestral property as per the CS records. So we got this not, so now we are not proceeded in the eviction case. So civil suit laws.
And even if there is civil suit pending, there is no entry order. It is simply we have filed a civil suit before the court below, and when this proceeding has been stalled. There is no entry order by the civil court.
Violation. And not the intention to disobey the court's order.
But there is this order was not to call including proceeding. See, there is no embargo. No. There is absolutely no order in the civil court.
They are claiming title.
But this is the government land, it is the embankment of it, village tax. They are imposing upon it, and the result of which the villagers are unable to use the bank, they are also not getting ways to approach the lenders. On these are on the case, this was filed by.
And who violated? And in the present contempt application, this is the problem. So that you don't include the persons who are going to be affected by any order which is to be passed by this court or by any other authority. So in this case, only Tahsildar is a party. Well, encroachers, you are fighting the case against the encroachers. They don't have any idea that this contempt application is pending. You take some order and then you try to enforce that order. Are you permitted to, where is the question of permitting now? That's after 5 years.
They entered application and they filed their application for modification of the order. That was considered all the parties were directed to apply for the procedure. They accordingly appeared there and submitted that suit equally. But there is nothing, no interim order in the suit to drop the contempt procedure.
The Regent. See, there is a dispute over title. You could have had suit.
But this is government land.
Government land, you have decided.
But we are using
You are using them. Petitioner has raised
it was incumbent on the state to take action from their end.
disobedience of an order of this court dated 3/12/2016, passed in WPC number 20181 of 2016. So, the petitioner had alleged in the writ application that there was an encroachment case number 85 of 2014 pending in the court of Tahsildar, both in the district of Bhadrak. But he was not proceeding in the same matter. So, the writ petition was disposed of with a direction to the Tahsildar to dispose of the encroachment case within 4 months. So, it is worthwhile noticing that it is apparent from the application itself that the Tahsildar was taking steps in the light of the court's direction when the opposite parties and the parties were inside. Miscellaneous application was filed by the persons who had allegedly encroached upon the government land, with a prayer to recall the said order dated 2/12/2016. The top. The court, later by an order dated 12/5/2017, directed the Tahsildar Board to dispose of the encroachment case in accordance with law by giving opportunity of hearing. From the materials on record, it appears that the persons against whom there was allegation of having made encroachment took a plea before the Tahsildar about their title over the land in questions and about the fact that they had approached a civil court of competent jurisdiction for declaration of title. So next, in the present case, the petitioner has alleged violation of the court's order by the Tahsildar, by the Tahsildar. So the then Tahsildar cannot be said to be liable of disobedience of this court's order, as it is the petitioner's own case that he was taking steps for the renewal of encroachment. So, when counsel appearing on behalf of the petitioner has submitted that there is no stay slash injunction passed by the civil court. In order passed by the civil court in the said title suit filed by the inquirers. So, stop. Next, in review of the matter, in contained jurisdiction, I am not inclined to proceed against Tahsildar. What is his name? What? Federal Procedural is name was Sarah Hendram. Sarah Hendram, the then, no, Miss Chinmay Kumar. Chinmay, yes. That was the exam content, somehow the Miss Chinmay Kumar Tahsildar, who had admittedly taken steps in compliance of this court's order to conclude the Encroachment case, although no case of deliberate disobedience of this court's order is made out against Ms. Chinmay Kumar. First of the contempt proceeding as against her is stopped. Liberty, the petitioner shall have liberty to take appropriate steps in accordance with law before appropriate forum at any stage as may be permissible. Yes. Item number 8, it's an item number 8. In the morning, when you have received the instruction, next week, I can file that. Next occasion, I already fixed time, I already. Further time is allowed for. Allowed to learn AGA to find so-called impact. Item 9. Item 9 में direction is given for direction is given for enhancement of the result special HR. But we have to pay the amount at the resource center. Yet there is no direction to file in favor of the let me see the order first. Yes, the order at page 23. Running page 23. Page 23. And the internal page 60 of the government. Yes. No, also not prepared there, because it's a A compliance affidavit be filed on behalf of the opposite parties, stating specifically that enhanced remuneration at revised rate, comma, a special allowance, comma, house rent allowance, and other incentives except the earnest allowance from the respective days, comma, as directed by this court, dated court by order dated 18/8/2017 has been paid to the petitioner. Yes. Yes, next.
Item 10.
Item 10 members, I am asking for the attender of the housing grade members. Grade members have a small here. Grade members have been given that the number of members referring to this of the year, having the reproduction earlier, having the benefit. But that was disposed of naturally with the direction to dispose of the representation. That representation has been disposed of. But my limit can find the representation number is 197 of 2015. This representation will be considered and will be prepared the consideration when we entitled to the this present position. By the petitioner themselves.
Yes, where is the order?
By the order by
Tender.
that will get 1 admission stage of the part the opportunity to have a counter manner. My humble contention, the year 2017, the software had gone like the share of the week on that day, but the petitioner requirement was returned on 31/7/2015. Yes, sir. 37/2015. The government software has common that extension of that is common is that is 8/6/2017. My one brother says but this information was filed on 28/7/2017. That is arbitrary difference after the software came into force. The software is prospective also. Last day, page 1/4. That's page 1/4. There is this has been disclosed because we have not yet received the petition. This is pending. Check it once have the lecture and found that it's pending. Customer paid for enhancement of department paid from 50/60. For notification of the government letter 8/6/2017. Due to pendence of the case in Honorable High Court, prior to issue of the notification, he will review the petition number 197 of 2015. So review petition, if review petition will be considered in the they will be entitled to. Otherwise, he will not be entitled to because of the fact that the petition was not there. So I will present this petition after this notification payment is force.
No, whether he is entitled to or not is private file and review application.
Review application of the because we review itself.
That it is the file review application or not.
After that, after the 2015,
They will be disputed. And after the order passed,
Application for what? So, review, just that you have you filed a review application. No, but you could have been informed by the petitioner that he. Application is for what?
Review application managed to review review order which was disposed of. When division that is review application arising out of WPC number 15535 for 2015. The petitioner their management request to be paid for enhancement of age from 58 to 60. That is not considered material. But what is not considered and there is a license
To material. Now come to the operative part of the order.
Their management then also is not letter implement and result consumers. And the last paragraph number 2 of the order. So only which chapter 27 2017. The notification of the government which is quoted under manner was of 8/6/2017. 2017.
Why are you reading this? Please come to the operative part.
So my question has come up, considering from our Prabhavata conduct page, there is that in the and part of system 1 and B equal with that as follows. There is in view of petition the benefit of given admissible, it is not given admissible, a given admissible on the part of system A and system B of the common case shall be granted to the petitioner. Then the one will be put under. The employee who left the court in the law, irrespective of the fact whether instrument of in favor of law shall be entitled to full salary after the age of 60 years. He moved it before government, this petition before government only on 28/7/2017.
Whether you will pay him or not. One line minus. Yes.
If that means not only one, many people are there. But they never got this.
Really, I don't know. I just know compliance of the order. I'm giving you 1 week. Take specific time. Pay or not. If you say no, then I will decide whether contempt is made out or not. And if once I decide that a contempt is made out, I will not let you go. I will take this matter on 1 week as the first case. Stop. The adjournment is being granted for the opposite parties to take specific stand as to whether they will allow, as according to them, the petitioner is entitled to the benefits consequent upon enhancement of age of superannuation from 58 years to 60 years. First off, the court will consider initiation of contempt proceeding against the contemners based on the stand which they take. First off, the court makes it clear that once they stand before this court, that the petitioner is not entitled to such benefits consequent upon enhancement of age, despite this court's order dated 28/8/2017, comma, they shall not be permitted to, the court shall not consider any apology if the court finally reaches a conclusion that there has been deliberate disobedience of this court's order. So I'm going to say, I would not spend the order of my life. That's possible. Only when very small, my instruments, some very like. State Housing Road, the personal present on the next day. Yes. So actually, there was some time one week, simple time they have to take. Whether this matter is that's something else. In 5 years, you must have understood whether it's entitled to or not. And the whole fellow is institution. If we are not let me see. Submission item 11. That is just another. Submission item 11, the decision is now taken and direction comparing the disposal of the RMC number 200/2017 on 6/9/2024. Let a copy of the instruction is submitted. Instruction was submitted. And then we can challenge that order to liberty. Liberty of Liberty, yes. I don't know what we are going to do. Item number 12 and for the content, and the petitioner knowledge. So Mahapatra was just here. Mr. Dani Mahapatra was just here. He is the appealing counsel for the BBA. In this case, the petitioner is aggrieved by the opposite party number 2 to action, whereas the petitioner was allotted with a scheme under a scheme of developing scheme under the BBA. The allotment is made in 1997. And clearly the order is that annexure 9, page 45. So the petition has been disposed of. The petition also will dispose of. My lord, the last petition, Mr. Mahapatra requested us for a copy of the application and that has been duly served. And the petition has been suffering in the last 27 years, my lords. And this is the great round of litigation before my lords. Into the petitioner's case that despite the court's order dated 13/1/2022 passed in WPC number 27518 of 2020, the petitioner's representation has not been disposed of by the vice chairman, by the vice chairman, Bhubaneswar Development Authority. First off, did the vice chairman, after having reviewed the contempt application of the prima facie view that a case of deliberate disobedience of this court's order in Meadows First off, let the vice chairman of the National Development Authority, the person present in court for this court to consider framing of charge against him. Yes.
Item 13, I mean, next week, Lakshmi, keep it the next week, Lakshmi. Fix the date, my lord.
Holidays, after holidays.
Lakshmi, 21 content, Lakshmi, 2021. 21 content, 4 years of content past Lakshmi. My lord, fix the date.
Fix the date. I have fixed the date after holidays. Yes.
Item 13. So 13 last to last year's already compared with all the pictures have been given appointment. They want to check out for 2008 years.
Compared with.
I will give a particular 10 years. Item 14. So, I think SLP is only lost was looked and you are silent number of complaint affidavit on 39 SLP by diary number 64202024 is pending.
Yes.
Item 15. It's item number 15 years. Under protection notice, SLP, so
SLP.
15, 16, 17, item 16. 15, 16, 17, 7. Say no, all 16, 17. Item 18. 18, compare. Item number 19. 19 may be words. 19 SLP is pending. Doesn't matter, but where the fact means, last occasion, my learning fund has taken time. So despite that, the SLP, subsequent issue and subject to SLP, they have given appointment to other, that I have given you. Then I have been given that score also. That's why directly last occasion to take instruction. Also I am doing it. In actually say item 19 and item 26 both are session. In that case, that was challenged with the honorable appeals court and honorable appeals court has granted the interim order to interim status quo.
So then they will have to maintain the status quo.
Additional appeal for a moment. Further information under the appeal, so also the advertising for a moment, my lord. It is the advertising of 24 and 25. If successful advertising for the self control, wherein it is categorical state, they cannot violate Supreme Court order. And at least the court cannot violate Supreme Court. Instead of this SLP, they have issued this with tendency of SLP status quo order, Mr. Counsel. You may commit contempt of court. I cannot. Now, they have issued the order of appointment to other candidates. That is my submission now.
Yes. Next.
Item 20. It was subject to result of the SLP and root appeals.
Should I record that? Can I record? SLP, this is Supreme Court. Should we make observations regarding tendency of cases before Supreme Court?
My humble submission will. All right.
Saying, Mr. Counsel.
But I will which are taking the advantage of citing mind here. We have a copy of order.
Yes, sir, that will illustrate that I have given you. Item 26, I showed that I have given that copy, madam. There are not some sort the copy. Then item 26. So I think so. In my show facts,
No, where is the order?
I have something before. If rather I have understood, I will give you a copy. Just.
Item number 90.
Yeah, 26.
No, I am taking up, I don't want.
Same model. So, what's the item about? 26 service of the next status
Petitioner in the present case application, present contempt application has alleged disobedience of an order of this court dated 6/5/2022 passed in WPC number 3A329 of 2021 and other analogous cases. No problem. If you will file, the way will file. Said order, writ appeal was filed, which was dismissed. For 30,000 so it is an admitted fact that against the order of the writ court, against the order passed by the division bench in writ appeals, the state of Orissa has approached the Supreme Court by filing special leave petitions, asailing the order of the learned single judge and that of the division bench. First off, following order has been passed by the Supreme Court in SLP number so and so, paragraph 5. First off, for the reason that there is a specific order of the Supreme Court that the parties have to maintain the status quo, there is no question of implementation of this court's order, violation of which is being alleged in the present contempt application. The contempt application has no merit and is accordingly dismissed. Yes. Item 20. Item 20 applied. I'm just looking. 21. In 21 itself is held. Several matters in training. SLP has been filed. One is address. One is SLP has been filed. What can be done? Non-compliance of order dated 21/12/2023 that legal construction, the construction was made by the private applicant for in the petition. And especially it's very difficult, Mr. Counsel. But it is very specific or there is no specific on. Yes, sir. Kindly also glance from the paragraph note 7, that is page note 13 here also. Page note 13 of my contempt application. Paragraph 7. Yes, sir. Also. What is paragraph 7? So means paragraph 7 at page 13. Page 13 is the repetition order here also. Yes. So repetition, no compliance, so no. In the result, the repetition stands disposed of the direction to the appellate of legal consular to consider the representation address to him as annexed 4 series and to take a decision at the earliest required to remove the legal construction made by the appellate court providing reasonable the party number is heard. That process, saying that construction, let that process be for that. Other side of that is heard. Yes, sir. The customer is not taking any effort. One of the process has been taken, and I have given that particular and that a part of that date that was directed that has been removed, and I have given that so that the process has been taken and the process will be completed within 2 weeks. Yes, I have just received the copy. No, I am not inclined. I will dismiss the contempt application. The received order will be the continuous file. The received order, you can challenge this order also. The petitioner has alleged disobedience of order dated 18/5/2023 passed in WPC number 9042 of 2023, which reads as under. So, it is an admitted position that the said order was passed on the very day when the writ application was taken up without noticing the persons who, according to the petitioners, had caused encroachments. So, be that as next to be that as it will, learn AGA has informed this court that pursuant to AGA has filed a so-called affidavit on behalf of the opposite parties in course of in the court, which has been taken on record. It has been stated that pursuant to this court's direction, steps have been taken and certain part of the encroachment found to have been made has been removed. So, in the court's opinion, no case of deliberate disobedience of this court's order is made out, considering the nature of the order and circumstance in which the same was passed by this court. So, the contempt proceeding is this contempt application is dismissed. Yes.
This is truly a content application, because the content
Same order. Where is the order of this court?
order मेरा annexure 1 page 11.
So what is the order? Again, this is encroachment.
No, my lord.
Which item?
So one mutation.
Procedure and dismissal to 38.
Yes, my lord.
Yes.
Mutation was mutation order passed in favor of me, my lord. Only to issue ROR in favor of me.
Only your representation was directed to be disposed of.
No, my lord.
Then,
They have now filed a so called expecting.
Mr. Counsel, what was the order?
Maybe, my lord. It appears the petition number, petitioner hearing second round of litigation.
Sir, you are reading again the entire order. What was the direction?
To conclude the mutation case number 1992, but depending on subsequent information, all in the development of
Petition case has been concluded.
but not then issued ROR matter.
Already. The right that I have taken stand in acceptance papers.
No, matter. They are coming after 7 years.
The petitioner has released disobedience of an order of this court dated 18/5/2023, passed in WPC number 9342 of 2023. So, the direction was only to conclude the mutation case number 1919 of 2012. So, it is not in dispute that the mutation case has been disposed of.
Yes,
Has been disposed of.
yes.
Also for the petitioner submits that despite inclusion of the mutation case, ROR is not being issued. So you said inaction of the opposite parties does not amount to contempt of the court in the absence of any such direction. It was passed without finding of any counter affidavit on behalf of the counter affidavit. In the absence of any counter affidavit, as the matter was disposed of on the very first day, also the contempt proceeding is accordingly dropped. Yes.
Okay, sir, the direction may be given, madam. Because after 7 years of practice,
That is not within my jurisdiction to issue fresh direction in contempt proceeding.
the state is the party, madam. Council is the
Council, it is not within jurisdiction of the court to issue fresh direction in contempt jurisdiction. Am I clear? But this it is not my within my powers to issue fresh direction.
Yes.
24.
And last petition, they have taken time to implement the order, madam. 24.
What is 24? What have they done?
We have taken time to implement the order, madam.
Not 24, that I will not make any mistakes. I will actually call this matter next week. So,
That time they will look into.
third time next week.
Last time. I'll take instruction like next week, but
Next week. Item 25, problem.
Wait, please, your lordship. Your lordship, I'm appearing through VC for the petitioner, your lordship. Your
Yes.
lordship, on the last occasion, the government was to receive instructions, your lordship.
Complied. If I can comply with Mr. Counsel, if, you can take a copy, you can have a copy of the order.
Yes, Your Lordship.
Yes, comply with.
Item 27.
27.
Can you see the last one?
So
Taking time last paragraph.
in this case, SLP is pending.
SLP is SLP.
28.
And then 28 may not comply.
Comply.
29.
29 may and for the petitioner. Last occasion, I tell them council to fine for compliance with the. See the order. Order is at annexure 1, my lordship, page 8. Operative part is at page 17.
Page 17.
Yes, page 17, para 11, my lordship, in the last 4 lines. I don't need to give it the last chance.
By way of last indulgence, the matter was adjourned to 2 weeks. So as to enable an counsel representing the contenders to inform full compliance of this court's order. In which the court will have no option but to proceed against the contenders. If you are not happy,
You look for the value to page number of the content person. I have put the order in question. Page 4, therefore this court by incorporating with the state order is inclined to drop the orders of annexure 6A and B to the deed of petition. While copying the same, this court directs the appellate parties to extend the financial benefits of due and ability in favor of the petitioner or the period from 25/4 to 1995 to their states of their
Case number 30 has not been complied with. If they are lucky, you will follow the first time, by that time it will be complied.
it's only about 75 was.
I have taken instruction during the morning that I will be complied and that taking
The petition is about 75 years.
yes, in 1 week, the order may be complied with. I'm just adjourning the matter for 2 weeks. And you are not there.
Especially, yeah,
and we are coming to such proposal and I have told me the government only and the order will be complied with.
See, we should initiate contempt proceeding only when we find that they are intentionally violating. If they have intentions to implement them,
intention you lost me time to call the page
let us wait.
You can see my instruction from my mobile that some lesson that I do that will comply with.
They will comply with
So many lessons.
Why should they not? Here, what 31.
Item 19/12/2022, till now not complied. Till now not complied.
Where is the order?
Annexed to 1.
Mr. One is not the order. Where is the order? Have you quoted the order or the next? Have you annexed the order? When you see where is the order, which order has been disobeyed? Basically, madam.
19/12/2022, The WTC number 3412/2022.
So the objection case is pending before whom?
Before the sub-collector,
Before whom the objection case is pending?
hello,
Before whom the objection case is pending?
this additional sub-collector, Bada.
Yes. Instruction is found by the order was met. And let me lesson come. 32.
And now behind the order is 38.4, madam. 38.4, you also there is and who complied the order. Under the order of
So what are you saying? 38.
38 also like director. So, and
Thereafter, on 17/9/2024, his pension petition has been forwarded to the exim and it is under process that will be sanctioned very shortly. On 17/9/2024, step 7 taken for release of the amount.
yes, and director was so
Come after 4 weeks. The steps will.
already
They have questioned the Accountant General issue authority slip.
so at least police will also
Accountant General is not a party.
accompanying with the party.
Is a party who is a parent. Who are representing. Then why don't you ensure how much time do you take normally? I will obtain instruction to that. I will obtain instruction. So let you come after 4 weeks. So meanwhile, to ensure that these are court cases. The office of the accountant should expedite such matters. So 4 weeks. 32.
In WTC 963/23,
So where is the order, sir?
assist my
Pending in this case, ma'am.
Writ of appeal is pending.
Yes, ma'am.
I have no instruction. I have no so far instruction is concerned.
No, you can accept notice in writ of appeal right now. Right.
I am neither my client has been noticed nor I have been informed.
You have been informed, this notice. It is stated by one counsel representing the contenders that a writ appeal has been preferred against an order which has been alleged in the present contempt application. Stockland counsel appearing on behalf of the petitioner states that he does not have any information about filing of the writ appeal. First off, let a copy of the writ appeal be handed over to learned counsel for the petitioner in course of the day. Now you have the knowledge. Right.
Concern my work.
The petitioner shall be at liberty to appear in the writ appeal.
So, when you say, so far nothing in the lead.
Difficulty, Mr. Counsel, is that there is writ appeal and there is a contempt proceeding. See, but how do you
complied with.
Every source in the small is
Later. So,
order dated 23rd March 2023, let's see. See the order page, running page 8, let's see, the promotion given to the.
Annexure one.
to the Annexure 1,
Is the order.
running page 7. Let's see. Promotion given to the petitioner to the rank of a head clerk. In the meantime, the vigilance case has, the petitioner is acquitted the vigilance case. They have not challenged they have not challenged. They feel today and not been promoted to the petitioner. So the last occasion, 3/5/2024, taking time to for filing of show cause, that is nothing.
So since that order that annexure one, so the direction given that despite pendency of the vigilance case, it will given for other promotion subject to outcome of that vigilance case. And his case was considered in the DPC, and it was found that a departmental proceeding is also pending. And the departmental proceeding at the vigilance case is pending, his promotion cannot be given in view of the division bench decision. Now the state has decided to challenge the same. In the decided to challenge this order, because that if this will be implemented, this will go against the order of the division bench. That in division bench has decided, we will commence a vigilance case or departmental proceeding, one cannot get
Instead of filing appeal in this order, you can conclude with departmental proceeding.
Yes, no. That can be done, but the state has filed a contempt petition for that reason, it can be pushed and do disciplinary proceeding member
Charge.
the charge. So in 2022, departmental proceeding was initiated. So conclude about
Shall already been taken. Three times have already been taken.
See, rightly or wrongly, a law has been laid down that if a departmental proceeding or a criminal case is pending, you don't have any right to be considered for promotion. This is the law. And you will have to accept that until that order is set aside. You have been acquitted of the criminal case, departmental proceeding is pending. The court wants that in the meanwhile, the departmental proceeding is also concluded, then you will get able to.
Identical case is the IDP, self-some ground as a departmental proceeding. The self-some ground, not departmental.
That's encroachment. See, the standard of proof of charge in both the cases are different, you know better.
Yes, sir. Just the fact that the departmental proceeding was pending investigated.
My knowledge.
Since he has been acquitted, has requested on behalf of the contenders, list this matter on 4 weeks.
Regarding candidate based appeal, regarding pay and consent. आपके द्वारा डायरेक्ट नहीं करते आपके चांस अभी अपनी पति पसंद है तो रिप्लेसमेंट पे चला कर 60 मिनट में डायरेक्ट वो अदर का अपनी कंप्लेंट करने में 65 सेकंड kan saya 60 मिनट में 60 मिनट में डायरेक्ट डांस चला और नंबर 6 स्मेल द ऑर्डर that request appeal about paragraph 6. really answer 15. Answer, 413. 413. Answer 2. 413. That is the 15 of the writ petitions. Come to page 6. That is answer 1. That is answer 1. Sorry, madam. Answer 1. Page 9. Answer 1, page 9. Accordingly, they are recognized in these areas. After my the second thing therefore, direction 68 is outside to comply the order. Then pension has been handled. No, pension has not been revised. Pension has not been revised. And no, but let's see, he has submitted his pension paper on 17/7 to 18/7/2024. In compliance to pension paper, proposal has been submitted to the government on 27/8/2024. Submitted your pension paper recently. That seems to be that 75 years old. I madam and government direct last time directly without your pension papers, whether they could have proceeded since July control since July, like 2010 July 1. Since July 24. In more than 3 months to retire 2 months. My knowledge I can see directly. No one time will after unless no yes, madam. So that's direct there. If you were clear that you couldn't take serious matter, not from that. Compliance we have been compliant with. No pension non you have some since this is pensional benefit, I will take Mr. That's how we pay even payments. Last time, matter on 4 weeks. It's for the full complaint. All right. 36. Compare with one appears. 37.
37. Milo 2 weeks. Last order passed at 2 weeks. Of high
Yes, next item 38. Net legal losses. About the case, 13 July 2023 has not been complied. Operating part of the order will kindly at a glance. Direct opposite part number 4. To look into the request of the personal by the annexure 3. And by the annexure 3, the original lead person, the religious and amount of rupees 4,33,300. The direction also look into them. They must be looking into. Has not grants for religious and amount of rupees 4,33,300 in respect of elected from 9 October 2000. Yes. Now, we have always stated in plain manner. After the plain manner, some of several have already been paid to whom, madam. Now, balance color, we are pursuing the penalty. It was saying that, let's become my lord. The operating part of counter application stated that fraud is not available since 2016, my lord. No petition earlier has been filed. Contempt petition against earlier was there. Instead of that, fund is not available. Let me be sent to the collector for granting of fund. My lord, you have why did the petitioner now petitioner your fault is that you got this order. You should have got your right adjudicated upon by this court. So you got an looking into the petitioner has released the proceedings of this court's order dated 13/7/2023, passed in WPC number 21560 of 2023, paragraph 2, of which reads as under. Stop. It is the stand taken on behalf of the contenders that in the light of the said order, the petitioner's grievance has been
looked into and the amount found admissible has been paid to him. So stop. Next, in such view of the matter, in the court's opinion, no case of deliberate disobedience of this court's order is made out. Stop. It will be open to the petitioner to raise his grievance before appropriate forum in accordance with law, if according to him, the amount which he is legally entitled to is yet to be paid. Yes, 39.
Your worship, last exam, one and government advocate have taken time to comply with the order. Yes, 9 Annex 1 is the order, you will see. Direction was to dispose of change of status of land from Bakalasit to Sunna to Stitiban, pursuant to government notification, keeping with the Annex 2 worship. Annex 2 is clear, that's correspondence for changing of status of land. In that, nothing will communicate with the petitioner. Page 9.
So the decision has been taken.
Madam, in fact, the decision could directly to dispose of the representation, madam. Representation is down that we have taken, we have purchased from lead player. So prosecutor has initiated proceeding and called for the legal with settlement, madam. So lots of ransom time. Nothing has communicated to the person. What communicated? What is the order? Madam, to consider me written unacceptable.
Yes, keeping in Annexure 2. Yes, so that's why he is keeping in Annexure 2. Annexure 2 was admitted.
Because the government notification is said that so from this mode is concerned, government will allow to for changing of
Any affidavit filed in that case.
yes, my lord, that was the annex, my lord.
This affidavit was filed on behalf of the state.
No, nothing.
Nothing.
Nothing. At the stage of admission that I disclosed of.
Why no affidavit was filed?
Because at the stage of admission, it was
At the stage of admission. When have you filed the writ application?
contempt application.
No, writ application.
The lot of writ application are filed. 22
I requested on behalf of the supposed parties, this matter on 2 weeks. Item 40.
in this case, madam, we also directed to complete the investigation, madam. In fact, the investigation will complete a final formation.
I'll take instruction from the client whether it's the
Let me
complete.
see what was the order.
Lordship, page number 12, your lordship. Relevant page number 13, para 5. This content is arising out of the CRL and the petition, your lordship. In para 5, the court has directed inspector in charge to complete the investigation.
So it says that charge sheet has been submitted.
I'll take instruction whether it's.
What?
Sign the ticket.
The petitioner has alleged disobedience of an order of this court dated 5/5/2020, parcel CRLMP number 842 of 2023, which was disposed of with a direction to the inspector in charge, Kendrapara Sadar Police Station, to complete investigation of Kendrapara Sadar PS case number 231 of 2023. First off, it is stated by one counsel representing the opposite parties that upon completion of investigation, a charge sheet has been final report has been submitted by the police. Full stop. Next, when counsel appearing on behalf of, you don't have any information. When counsel appearing on behalf of the petitioner states that she does not have any information about filing of the final report by the police. Full stop. Law requires that it goes without saying that law requires that before acceptance of a final report, the informant, you are the informant.
Yes, Lord.
The informant is required to be noticed by the court below. Next, in any case, in the court's opinion, no case of deliberate disobedience of this court's order is allowed. The petitioner is the respondent of, petitioner is the informant of the said case.
Complete copy will be served up.
Charge sheet you will get, sorry, the final report, you will be noticed. The court has a duty to inform you. Before they accept the final report, the court will notice it.
No, in this case, my lord, without filing an additional complaints affidavit. 41. 41. 41. 41.
41. That's the man.
What is GPEX? What is GPEX? GPEX is a private limited company. Arising out of arbitration matter. For what happened, this is
You did petition, huh?
root petition arising out of arbitration.
The rate of appeal is pending. Rate of appeal.
Application from root appeal is pending now. The other appeal is already closed. So the root appeal has to be hard action. Because
So whether it's been taken up together
Should be order and the challenge in the writ appeal.
the root appeal
from
the order dated
2023.
So you want all the matters to be taken up together?
Yes.
That council. So you want me to hear this 41501, which is written petition and
No, next week, not today. Because root appeal, unless and until the root appeal is paid off. Root applications from root appeal.
so writ appeal is in order.
Order.
It's order.
Order dated 20.
Twenty-one 12.
20th December.
20th. Election anyway after the vacation review.
So why have these matters been listed before? Mine have to sit. When do you want? As jointly requested on behalf of the party, list this fact, these matters on. For this, yes.
Blood challenge. So, without filling additional contents of the, and also solving. Let me call this matter next week so that I will take it, sir. And the additional, I've solved. Additional complaints of the. Just now they have solved. I'll take it.
As an additional, hence I believe it has been filed, a copy of which has been served upon the counsel for the petitioner today itself. It seeks adjournment. When counsel for the petitioner seeks adjournment to consider the said compliance affidavit, is this matter on the
So let's call it after that results.
42?
And then do my lords. So last time there asked for ransom time for compliance. What house for open time to comply the order?
The order.
I should do. I should prepare nothing. Last time every time we comply the order. Actually, let them comply by the bill or 13.
So what is the order?
Problem is not only set aside and directed to address the attention. What not there, time to
The order.
I don't know. After one ten nine, operating you allow him to continue service. That
Yes. Ransom time. No. No time.
No, at least one time, melon. For contents level.
Letter.
Melon, this is clear.
So who has to comply with it?
This is melon.
Why has he not complied? Not, and when did he write letter?
Ransom time,
When did he write letter?
letter. What's the time to be last day, so that 2024 melon.
24, you had already written the order before writing the order. Letter.
There are letter.
No, such inactions cannot be taken so lightly.
No, ransom, as a last thing,
Is this matter on 1 week? When this court will consider initiation of contempt proceeding against the superintendent of police, which if in the meanwhile it is noticed that this court's order, violation of which has been alleged in the present contempt application, has not been complied with. Yes.
Item 45.
Yes.
45. Well, important ransom time.
Right. 4 weeks.
No, the 46. 46 ransom time.
4 weeks.
47. 47 complied.
Not soft remain in my lord. Levels are soft, my lord. So that I will put the stop remaining.
Instruction.
It's in fact, as per 9 step rule today in the morning, my lord, the order has not been complied with.
Please see the order.
My lord.
Item number.
47. Yes, 9, my lord. Electricity running this 9, my lord.
Just a minute.
The last amendment was directed to submit the objection and with filing the certified copy. So you have to do not submit the copy and they have to be kindly amended directly to solve the copy and with certified copy. Last amendment directly to file directed to the Learned Counsel for the consumer to submit the objection and certified copy of order of mutation case 26/22. This is the last order, 38/2028 circulars. This is the last order. If you reach the order, you reach the order, 38/2024. What is the order? In the order, you is directed to Learned Counsel for the consumer to file the objection with order of the mutation case number 26, demarcation case number 26. We have a copy of the order. No, I have no copy, right? You must say, because we have to pass 3 orders. As we the consular pass in demarcation 3 orders. Have you seen the order? The order is there with me. Did not give me the consular, did not give
Petitioner has alleged disobedience of this court.
certified copy applied by me.
Yeah.
Did not give me.
Has alleged disobedience of this court's order dated 24/8/2023. What is this? Reads as it is evident from the court's order that the petitioner's prayer was innocuous in nature. Stop. Next. Then AGA appearing on behalf of the estate as both parties has submitted that this court's order has been complied with. Stop. In any event, I do not find any intentional, do not find that any case of intentional disobedience of this court's order. The proceeding.
I have gave that copy in actually. And I think kindly see, they have intentionally given that
If they have the intention, then please punish them. All right. I have decided that they should not be punished.
I get and roughly questions here, roughly person was represented by a council. The kind of order which you have seen. You must say that order is the family that you done to your client. So let's say basically the only justice I had is that acting PL and completely order is not highlighted by the council. They have to implement the regulations from the only report.
Next, Title 49. Comply with it. Comply with something? Yes. You better have it. I don't Yeah. Page 28. That annexure.
Annexure 1.
So which part of the order has been disobeyed? Are you sure?
And that's
I'll give it time. Which one is?
Transfer during their division. That is the product.
Where? Which paragraph? 17 and there.
17. Yes, last. The court will consider that.
Yes, yes, my lord, I have highly spoken, reply, my lord. Have you seen the so-called reply? My lord, these allegations that the petition has been transferred in current department, to current division. Instead of repeat again, my lord, let's kindly see these allegations. Then what is the? Well, actually, just start making the some they are not. Where were you working? Tiger protection course. PPM. Yes, order of just let me understand first. So your parent division is Naranpur, transferred to Simplipal, SCPF. After the order of the court, you were directed, required to be repatriated. Yes, also kind of complaint certificate post 3 million. Complaint certificate I have stated that the petition has been transferred to the respective current division by the office order number 64 that is posted to in compliance with judgment of this honorable. His current division is private court and his repeated to division. Yes, the petitioner have been transferred, they allow him to make a submission. Paragraph 4, my lord, what's it kind of see? Page 4, my lord. Who of your affidavit, my lord, complaint affidavit. I have to show the order of repatriation. My lord, I have not entered, then I will enter that order. 2 weeks time is allowed for the contenders to produce the order of repatriation as was directed by the objection by judgment and order dated 1/2/2024 in WPC number 3004 and 30085 of 2020. Yes. Item 51.
Not the order dated 13th September 2023 in Annexure 1, page 9, para 7 have not been complied.
Let me see.
Now, I was going through the result, the requisitions can dispose of, which a direction to the
Yes, representation disposed of. Disposed of.
not dispose of. I have read it. Not dispose of. Well, a limit, the Tahsildar have roundly higher providings to unauthorized increment in the improvement. Now I am not reading the order of the Tahsildar. I will not see that. Eviction has not, we had admitted that there is enforcement.
Sir, counsel, there was no direction for removal one.
Okay, yes, sorry, then direction, including the enforcement of the ensure eviction and demolition.
Mr. Counsel, all right. I am not satisfied. The petitioner is alleging disobedience of an order dated 13/9/2023, passed in WPC number 29901 of 2023. The top, the petition was disposed of on the very same day when it was taken up after its filing. The top, the petitioner released in the petition encroachment caused by private persons over passage of road. So the persons who, according to the petitioner, had caused the encroachment were not noticed before disposal of the petition by the aforesaid order. So, in any view of the matter, it is here stand taken on behalf of the contenders that petitioner's representation has been considered and disposed of after following due opportunity. So, next learned counsel appearing on behalf of the petitioner states that the encroachment that the eviction has not been removed. So, I am not inclined to entertain a contempt proceeding in the facts and circumstances as noted above. This contempt petition is dismissed.
Within para 9 of the show cause, they have told that it is humbly submitted that due to very civil and provision to be done in another day. In para 9 of their show cause.
Next, item 52. It will comply with me. What was the order? My order is come to the encroachment. Comply with item 53. It will comply with me. Comply with 54. It will have done some time. How much? What reason? Where is the order? Order is that ordering person is at page 24, my lord of the contempt petition, paragraph 13. The following reasons, therefore, the writ petition is allowed the interim order under Annex 3, 4, and 6 are hereby set aside. The opposite party authorities are directed to approve the appointment of the petitioner with effect from 12 June 1992 and to confer all administrative contempt to 01. Yes, sorry. Last time also on this election, I am 54. 54 now. It is also second time contempt, my lord, as contempt brought in giving time. Can work everywhere. Where is the order? As contempt, my lord, at page 25. That in giving 1 month time on 14/12/23. Last paragraph. On page 25, paragraph 4, considering the facts and circumstances of the case and upon hearing and counsel for the parties, this contempt petition is disposed of by granting 1 month further time to the opposite party continues to comply with the order passed on 19/4/23. However, if the order is not complied with, ransom time. 2 weeks. That's your matter. 4 weeks. 4 weeks. No. It's high to work.
Highly complex.
Yes, well,
Item 55. In this case also done some time, madam. We have to, but are dismissed and we are now going to implement it.
for which
Right. 56. 56 complied, madam.
complied with
As per instruction today.
Let me see the order. Nine is the contempt. I'll go for it. Page 9 of the contempt petition, para 8, madam. In the result, the read petition stands disposed with the direction to the opposite of to ensure expeditious disposal of the DVP case number 49 of 2017 and ensure removal of enforcement as soon as possible and to complete the entire action audit.
Answer answer.
That is one part. The next, UAP case 49 of 2017 is there. Initiated on some part of the entire government club. Government club is enforced and almost the 95 to 99% is enforced. Which is a public road, my lord.
the petitioner has raised disobedience of an order of this court dated 16/10/2023 passed in WPC number 30412 of 2023. The petitioner had alleged in the petition that illegal encroachments were caused by private persons on a public road. First off, the private persons, said private persons who they were inferior parties. The private persons who, according to the petitioner, had encroached upon the public land were not included as parties. First off, the writ petition was disposed of on the very same day when it was taken up on 16/10/2023 with the following observation and direction, paragraph 8. First off, next, it is the stand taken on behalf of the contender that the case number 49 of 2017 has been disposed of. Has been disposed of on 11/7/2024.
Thereafter, another petition that is there, but seen and the petition of 178/2024.
When counsel appearing on behalf of the states that the entire area of the land, which was subject matter of UAP case number 49 of 2017, has not been taken into consideration. Be that as it may, be that as it may, considering the circumstance in which the order of this court dated 16/10/2023 was passed, I am not inclined to pass, and keeping in mind the subsequent compliance on behalf of the opposite party that is noted above, I am not inclined to proceed with the present contempt matter any further. The contempt proceeding further, since no case of intentional disobedience of this court's order is made out, the contempt proceeding stands stopped. 57. Liberty.
Last of all, directed to file the continuous affidavit
Regarding the removal of the encroachment, your lordship may kindly see the order passed. Page 19 is the operative portion. The result, the writ petition stand disposed of with the direction to consider and examine to take a.
This is 2981.
398/57. The operative portion of the order is at page 19. Direction regarding removal of the encroachment matter. 8 encroachment cases were registered against the encroachers. They were put to notice. They were asked to submit documents to show their title over the land. They could not produce. They were given 30 days to remove the encroachment. They have not removed. In the meantime, action has not been taken because of the monsoon season. That is the instruction I have received.
The petitioner has alleged disobedience of the court's order dated 5/10/2023. Operative portion of which reads thus. First off, it is evident from the records that before passing of the said order, no, the opposing party did not have any opportunity to file any reply. First off, the persons who had encroached who had allegedly encroached upon the public land were not noticed. First off, have you done something?
In the meantime, 8 OPLE proceedings were initiated against the encroachers. They were asked to produce document towards their title over the land. They could not produce. They were directed to remove the encroachment within 30 days. They did not remove. Now they have constructed permanent dwelling house over the property. So because of the monsoon season, no action has been taken.
Already EGA appealing on behalf of the state has however submitted, opposite parties has however submitted that in the light of this court's observation, proceedings under OPLE Act full form were initiated against the encroachers and they were asked to produce their right to occupy the public land in question. First off, as they failed to do so, the orders have been passed.
They were directed to remove
The encroachers were directed to remove their encroachments. The encroachments formally submits have not been the encroachers have not removed the encroachments from the authorities for my contents are waiting for rainy season to be over for further action of removal of encroachment. So, next. Considering the facts noted above, no case of intentional disobedience of this court's order is made out. Dropped. Yes, 58. Order has been complied with. Page
11. Order of the
my own safety.
So the petitioner has covered the state. The state and the state in the split state question knowledge. Now they said
Why that happens? The state council could not dispute the position. How could the council agree? What is the date of filing of the writ petition?
filing number is 1/8/2023.
1/8/2023. On 25/8/2023, your writ petition was taken up and the writ petition was dismissed. Well, the petitioner has raised disobedience of
the order has been complied with. You also may kindly see page 11.
Yes.
There was a direction finally to consider the case of the petition. So they have considered and rejected.
The The petitioner has alleged disobedience of this court's order dated 25/8/2023, passed in WPC so and so. Whereby the court had directed the opposite parties to consider the petitioner's case in the light of Mayanam City versus State of Odisha, civil appeal number so and so. So is submitted by AGA that the petitioner's case has been considered and it has been found that the petitioner's case is not covered by Mayanam City, bracketed Supra. So, in such view of the matter, in the court's opinion, no case of deliberate disobedience from this court's order is met out. Liberty? Yes. 59. 59, my lord.
Relevant portion is page 13.
Sorry, case number 60. 59.
59, sir.
Yeah.
And actually on page 10, relevant portion is page 13.
Yes.
Person, result of all such orders clearly show that the order of the proceedings for mutation of the ROR in favor of the petitioners has been confirmed and the state opposite party have failed in their attempt to before all such higher forums. No materials have been placed and the order of the procedure has been challenged in the higher forum before the Supreme Court. As such, no implement to implement the order of procedure under Annexure 7 to issue the unified ROR according to the order of the petitioners is allowed and the procedure Sadar Baneswar opposite party is directed to issue the unified ROR in favor of the petitioners. After his own order dated 16 December 1996 passed in mutation case number so also it will be order 12 months to get better receipt of the
Yes, yes.
after the order was passed in the mutation case, while they were in the process of mutating, they found that the fraud has been committed and Gramya Jungle land, the land is a Gramya Jungle, could not have been registered as.
So having challenged this order,
In the meantime, the Tahsildar has already moved the collector regarding this because since fraud has been detected, they have moved the authority.
still you will have to challenge that. All right, totally file your reply.
Fine. Item number 60.
But this is the matter in which the petitioner is the distress land and staying in the house is by the virtue of the order of this Siddha Hestian. The previous matter is that in that person she has to give in rent and out of that loan she will manage herself. Because divorce was granted and the petitioner's husband was not in any job. But his father as a rich man including different houses. The man for the present, as because the husband has no income, that's why court has been directed to allot that house in her favor so that she can give some part in rent and out of that rent she will manage herself. Since 2013, she was staying there, giving persons in rent and out of that rent she was managing. In 1919, those present women are staying in the house and neither they are making a living, neither giving their house to everyone. In content matter, it is page 9 here.
There is no direction.
This is earlier might hear or something, and the order given by this court is something, but they have given only she is going to collect the
Those facts are immaterial. We are in contempt.
direction is given that investigation as well first FIR filed, she filed the first FIR and she has given to investigation and steps. But in the FRC has also mentioned that they are staying in.
Cannot go into those aspects.
Yes, ma'am.
I cannot go into those aspects. Action was to file complaints.
Yes, ma'am.
File.
Will also may kindly see the order at page 20. Page 20. The order passed by this honorable court, 16 to 2024.
Page 20. Then there is an order. Are you appearing 3867?
67.
Page 20, something else. Page 20 is their file. No, madam, sorry.
Time was taken by the 11th Council for the state, but the report that has been taken by the.
Time.
These
I don't know, see instructions only.
Yes, sir. They have, in the notice is there that instruction is there, but they have not sub copied.
What is there to be implemented?
Once he filed the FIR, according to the FIR, they should take investigation and give the report. This is the order of this honorable court.
May kindly look at the order.
You have seen. There is page 10.
Yes, sir. Page 9 and 10.
It's very difficult. Just 60 dollars next. Application and decide find the distribution of those courts order. After the person of which this the given a better solution that the petitioner that file a complaint petition and file a case. Stop, which has been registered. Stop in such view of the matter in the court's opinion. In case of delivery disobedience of this court's order now. Yes. 61.
My last petition was also directed to prove that instruction 69/2024. You'll also the writ petition was disposed of referring to the judgment passed in case of Mukunda Devi. In case of Mukunda Devi, state has preferred SLP pending before the Honorable Supreme Court. That is SLP number 33172 of 2024. That is pending number.
Yes. Yes. No. The petitioner has renewed disobedience of an order of this court dated 29/8/2022. Passed at WPCOSC number 1259 of 2017, which was disposed of in terms of an order of this court passed in Mukund Devi versus State of Orissa, WPCOSC number 623 of 2010. Next, the said decision in case of Mukund Devi bracketed Supra is under challenge before the Supreme Court by the State of Orissa. Now, while SLP 33172 of 2024. Yes. 62.
This case has not been filed. This case has SLP not filed. These cases.
So this case cannot be, yes.
We are relying on
Depending on the case.
yes.
Yes.
So similar 60
Similar.
62 similar. Here also we have filed the writ appeal against the order. This order also 63 also same. Up to 64 same matter.
Yes.
Item 65.
It's a non-compliance of the order dated April 2023 by the collector who did not comply the
Where is the order?
order is an annexure 1.
What is the order?
To the last page, page 20. Para 13, pursuant to which petition is allowed for interim order under annexure 1 is hereby quenched. The office of party number 1 is directed to issue
The order passed by this honorable court the collector fully had referred to the revenue department, and the revenue department is in consultation with the GA and PG department, and if your lordship may grant us 3 weeks time, it will be all right. 3 weeks.
Oh, Lordship,
There is
sir,
a process of complying.
she is not getting appointment.
Yes, yes, therefore you have filed the contempt application, therefore I am adjourning, I am not dismissing your case. Come after 3 weeks. Okay.
3 weeks means after vacation.
Yes, after it.
It will be before vacation.
Before Diwali,
No.
before holidays. Yes. 66.
66, the order is at page 33, annex 7.
Annexure
7.
7.
Yes, madam. The contempt petition is filed for non-compliance with the order that was filed for 23, passed in WPC number so and so. Considering the subsection,
Just, where is the order?
page 33, madam, annex 7.
33, yes.
Considering the submission now, this court by
It's all order passed in contempt petition. Order.
that is annex 4, page 26. Present petition has been filed by the petitioner with following prayers. It is therefore humble prayed that the honorable court may be graciously pleased to issue a writ of mandamus to the opposite parties. Direct representation has been disposed of. No, my lord. Thereafter, further direction has been issued, my lord. In the contempt petition,
Very difficult.
no, your lordship may kindly see. Kindly see. In that, it is a series of writ petition was filed. They have filed series of orders. I have stated that.
They didn't file.
What is the order? Order, I'm not to place the full order. Full order is not. The sites, submission of the government council was taken. Government council cannot give information. Instructions. This is the fourth end of it. They need the administration of the rights. That way. So it is the question of giving the direction to the opposite parties where my service book has not been decided. My service book, you see, this is not done. You file, you seek relief for disposal of representation. That is, no. You are actually kindly look at my grievance. Kindly look at my grievance, my lord. That is there in the annexure 4, page 26. Page 26, kindly look at my grievance. Considering my grievance, this already directed the opposite parties to look into my grievance. Come to paragraph 4 of the order. Paragraph 4. Yes, my lord. Yes, in course of hearing, it is submitted by the learned counsel for the petitioner that the petitioner wants to make a press representation before the authority concerned with the direction from this court, the authority to consider the case of the petitioner within a stipulated time period. Thereafter, considering the submission, para 6, made by the learned counsel for the respective parties and both in consideration the background of the fact that this court
the instruction the proceeding instruction as to whether the petitioner's representation has been disposed of or not.
they were asked to submit the compliance report. That is what I submit.
Nothing, no more than disposal of your representation.
Since last 30 years, they have not updated 30 years to come to substantive case. If the right they are indicated upon, then the order of the court. It consults that one example where the rights have been adjudicated upon and they are not complying with the order. I will send them to jail. About these orders.
Yes.
Get the right adjudicated, then see how they answer enforced. Considering our submission, the Sangable. So, yes, after holiday. 67. Yes. 67, pursuant to the direction of this honorable court, original pension has already been approved. Yes, ma'am. Original pension has been paid.
Procedure, this could be received now.
The direction was at page 18, you will also kindly see, having heard the counsel for the parties and considering the fact that the order of termination has been set aside by the tribunal, which has now been confirmed by the honorable court, this court, while disposing of the writ petition, to release the provisional pension in favor of the petitioner due and within the period of. Margaret, just go through the order and next week just tell me whether the order has been implemented or not. And don't ask the senior to appear. No. The provisional pension has been letter 68. Supreme Court in one hard case, in the connected case also, we have filed writ appeal under 102 of 2020. Writ appeal 69. 59 application. This is a past contempt application for non-contempt order 20 November 2024. We have filed the compliance affidavit to writ appeal is pending. Writ appeal pending. Level 70. Now, non-compliance of the order dated 21 to 2023 matter. Page 17. Page 17. Item 17. Page 18 matter. I'm sorry, my item 69. Where I said the reproduction, that is, I'm incorrect, madam. Here we have filed the compliance affidavit that the encroachment case has been disposed of. That amounts to compliance. 69. Writ appeal. 69, you have filed writ appeal. No, madam. 69, the encroachment case, the writ appeal was previous matter where my friend was appealing. 68. 68. This is 69. 69. 69, the encroachment case has been. 69 was filed. 68, writ appeal in both the cases. Yes. Item 17. Now, non-compliance of the order dated 21 2022 as page 18 matter, paragraph 6. Considering the submission made by the respective parties, this court modified the order dated 26/2022 passed by the. Yes. Pending. SLP number 28504 of 2024. Pending. Yes. 71. Order is at page 14 matter. The 11 portion is page 16. 6.1 paragraph. Placing reliance on the decision cited above, the decision of Mutamati versus State of Orissa and WPC number 2584 2016, this program for 5/7/2022. We have filed writ appeal number 2288 of 2024. 72. 72 matter. By the order dated 4/10/2023. After the honorable directed the opposite party number 2 to proceed in the case of the petitioner within 3 months. Third case, paragraph 5. Considering the submissions made and without especially any opinion on the limits of the case, this court directs opposite party number 3 to take a decision on the evaluation of petitions compliant. 73.
Yes, when this case was disposed of, keeping in view the Afghanite case. And Afghanite case subsequently,
It has been remanded.
so it has been remanded, set aside and
The, 73.
73.
The petitioner has alleged disobedience of an order of this court dated so and so, whereby his credit application was disposed of in terms of, this is 4275. It's contempt petition 4275. Where is the
Afghanite, in the order, they have reflected.
in view of the decision rendered. This is the order. Yes, can. Are you alleging violation of the next one? Where is the alleging violation of the next one?
Annexure 1, they are claiming violation. And these writ petitions were disposed of keeping in view the judgment at page 14. That is in case of Akshay Kumar Naik.
Page 14.
Page 14.
Order dated so and so 4/8/2022 passed. No, not 4/8/2022. What is the order? What is the date of the order? The same date. Sorry. Order in both the cases are the same.
My lord, Afghanite, yes, my lord, same day.
Same day. Passed in WPC number, the anchor order and batch. Stop. The petitioner was granted relief in terms of decision in case of Arkan Ayat so and so. Bracketed WPC number 5480 of 2021. An appeal was preferred against the said order, which is true. Dismissed on the ground of limitation. So on the state had prefers SLP against the order of the division bench, dismissing the writ appeal. So the Supreme Court has remanded the matter, remanded the writ appeal back to this court for reconsideration by an order dated. That order by the Supreme Court decision.
I'll provide the copy, my lord. That copy was earlier. The supplementary list, there were two matters, same matters.
Yes.
Item 74. Welcome plans for adopted 9 January 2024. 9 January 2024.
Order already complied with speaking order complied with deadline.
75. Was not complied by order with the 4/10/2023 manner by the annexure 1 page relevant section page 17 manner.
Where writ appeal is pending. We received writ appeal number 1931 of 2024.
Yes.
76.
76 control lordship speaking order has been passed.
Complied with
What was the
speaking order first.
77.
Liberty.
Second contempt.
Speaking lordship 20707.
SLP pending certificate.
78.
78 your lordship similar matter SLP is pending also.
Similar.
Yes, your lordship. I mean parent the original matter the parent order that has been challenged. 78, your lordship.
Similar or
Similar matter, I was looking at similar matters of right. Similar matters.
not to Pradhan?
So much.
Yes.
79.
79, your lordship, speaking order has been passed.
Item number 82.
Yes, your lordship, the speaking order has been passed.
Details.
84 cases.
Details. 82 cases.
78.
And then there's the complaint. 84 cases, your lordship,
80.
speaking order has been passed.
81.
81, your lordship, speaking order has been passed.
And the copy is all this copy is out.
Yes,
82.
Sorry. 81 to read the order. All right, it says, yes, so many orders to me.
But we are seeing passing the order, and that's a part of it, then I will hand them. And that's what I said. But I see passing the order on that basis, isn't true, so the copy, 80 and 82, because if they are compliant, then we have.
83 on stand, your lordship.
81, 82.
Stand, your lordship.
18 to 80, 80, all of them, solve that.
I think so, this companies also.
82. 2 weeks.
Yeah,
83.
83, your lordship, repurpose is pending, your lordship. 2024.
84.
84, your lordship, repurpose is pending, your lordship. 2548 of 2024.
Yes.
85. No, these whenever in which case the present petition, the content, this is the second content matter. Arranging out of WPC case number 3750 2023. We have the order. Annex 1, 13 years. Certainly, but all this application, has 23 years.
Lordship, similar matters, SLP is pending, and the certificate.
Malayalam Sati is pending. The petitioner has alleged disobedience of the court's order dated 23/11/2023, passed in WPC number 37560 of 2023. In the light of decision of this, in the light of decision of this court in case of Malayalam Sati versus State of Odisha.
No. Malayalam Sati versus State of Orissa.
Civil appeal. Yes, Supreme Court, in Supreme Court, each matter is pending. What's up? Submitted that.
Malayalam Sati on the 29/2026
That it is submitted that the issue involved is pending decision before the effects court in case of Windows. I will just give the details.
So much.
So it will be matter.
So, and I was versus Southern Samantra.
State of Odisha versus pending. Amplification. Search of the matter. No case of intentional disobedience of this court order thereof. Yes.
Item 86.
86 speaking order has been passed.
My lord, I am VCR Puri, my lord. I am VCR Puri, my lord. So far, item 86 is concerned. And so far, annex for 1, running page 14, please make a glass, my lord, has not been complied with, my lord.
File a complaint affidavit to the Procedural Lodge.
And compliance affidavit has been filed. Take a copy. Yes,
My lord, only one thing, my lords. I crave only before also one thing, my lord. So far the compliance is concerned, the OP number 4 also directed to be taken side before the OP number 3, my lord. Then I shall have to ventilate my grievance before the OP number 3, my lord. Without observation, matter may be disposed of.
Giving the liberty.
Oblige, my. Oblige.
87. 87 not plus matter.
Not trust.
88.
Speaking order has been passed. Your Lord.
Order passed.
59.
59. Order has not been complied with measures.
4 weeks time. will be taken.
4 weeks.
90.
On item 91 in petition of doubt, on 6/7/2024, I want to file a substitution petition.
Substitution in contempt matter.
Still pending, your Lord.
Petition of doubt matter.
SLP pending drop. Yes.
91.
May I please, your lordship, with the second contempt in this, with the second contempt,
Forget second contempt. 80 is the first contempt. Let us come to the order.
that's ordered at page 11 of the writ application. Sorry, contempt application, my lord. This honorable court is pleased to pass a
Representation disposal. Disposal. Just a minute.
Your Lordship, CBA is the
CDA.
CBA.
What is for the CDA?
Mr. Banning the market will be approved.
Notice to the opposite parties. For them to explain as to why a contempt proceeding be not initiated against them and they be not punished for deliberate disobedience of this court's order. Yes, next. 92.
92, 3 weeks time. will be.
3 weeks.
My lord, my
Withdraw.
92.
Yes.
order dated 8/2023 has not been complied. Your Lordship, a speaking order has been passed on 30/10/2023. And the copy has not been sought.
That should be good.
94.
Non-compliance order that in matter 31/7/2023, Lord Smith and say approach A matter. 6. By disposing the petition was the included order that by 21/8/2021 under Answer 9 direct the opposite pen number 1.
Enhancement Setti is pending before the Supreme Court. Mayan Setti was order department. Mayan Setti वाला बता दो.
No.
Hindu father Mayan Savai.
Hindu size.
Since you are using
I will not be able
94. 94. 94. That is the address.
95.
94 speaking order has been passed. Copy will be supplied. Your Lordship.
speaking order.
Liberty may be granted to challenge this.
Liberty.
Obligation.
96.
Yes.
Since Bindusaga, well, since dismissed in the appeal on the ground of Bindusaga, now Bindusaga is pending. So you are sitting
Bindusaga. 19?
96 discharge.
96.
96. 97.
Order dated 8/February 2024 is non-compliant. Order dated 8/2/2024 is to be implemented. At page 12, my lord, 27.
97, yes.
No, so, see, the order was to take a decision in the light of your, so, order passed in between the internet of 2021.
Yeah.
And again, so,
Yes, the petitioner has alleged disobedience of the court's order 88 to 2024, passed in WPC number 2834 of 2024, which on 24. So by this order, the writ application was disposed of with a direction to the opposite parties to take decision on the petitioner's claim in the light of an order dated 25/9/2023 in WA number 810 of 2021 and batch. Stop. The said decision dated 25/9/2023 in WA number 810 of 2021 is under challenge before the Supreme Court, as stated by the AGA representing the estate of Orissa. So in such view of the matter, no case of intentional disobedience of this court's order is made out. This application is accordingly, the proceeding is accordingly dropped. Yes.
98. The claim has been complied with plus.
It's the order dated 29 January 2024.
It has been complied with, they are saying.
I have no instruction to comply.
I'm giving the copy of order that was dated on 2024, the order has been passed.
Yes, please give.
I take instruction.
Take it, madam. Let me see the order and then why should it remain pending if there is nothing?
Because I'm giving her a copy of, so I'm giving her a constitution.
In the direction of representation.
Direction or direct opposite Article 3 to take lawful decision on the objection made by the petitioner to the draft gradation list by annexure 8 within the period of 6 weeks from the date of decision.
That has been done. That has been done. They have taken decision. I'll give you the word to challenge that.
Okay.
99. Yes, the order dated 1/2/2024 is not compliant, but the opposite party number 3, issued one letter to my petitioner in the heading that the case number and the petitioner name is there. But while the complaints, they have put another person. That is in that was the petitioner Santosh Kumar Sal and another. But I am not Santosh Kumar Sal and I am the hospital manager. No. So that person's already put it there. My already been compliant. Yes, no, sir. When the top my case and my name is there, but the complaint, they say, the petitioner already there. So this is not my order. It's correct. So this court, my friend
it seems your client got the order, got a copy of the order from the office. Before for anything, but your representation was directed to be disposed of. Yes, the same person might have disposed of your representation.
Samsung, it is not my case. My case is that RSVP or before having the return,
has to be already done from. So I filed the representation with the
Order may be incorrect, you can challenge them. They have passed any order. The simple direction was to consider your representation and dispose it off. They are disposed of.
that is given by this office, my father,
Giving a copy.
Representation is allowed by the appellate party. If they do not
All right, asking them to withdraw that order.
yes,
so they are issue another order.
What are you talking?
My lord, I have to my lord. That order you have to try before filing the form that already sanctioned. So after sanction, I filed the, I would be my return the sum, I say that the disburse the amount.
After 1/2/2024, that order was not passed.
yes,
This is showing, you are showing.
yes, no, that's
That's not the order passed.
that the order was passed from 26, 2024.
Challenge an order passed in August 2024, which has been disposed of by an order passed in February 2024.
Yes, before that, my lord. Before the election, I said, my lord. That order have been now complied, that was already complied before filing of the requisition. So thereafter, I filed a requisition before the authority, sanction, that filed the requisition to disburse. So then the order passed, that requisition will be disbursed. So again, that order, this is the difficulty, and you are saying that there through one, so let's look at it from the page 9. That was the prayer in the interpretation. Page 9 of the petition. The petitioner therefore humbly pray that Honorable Court will legislation free to admit this case is notice of such and such. Mandamus by directing the third parties, particularly this was the differential area salary order analysis scheme. Therefore, reading prayer. I had already ordered. So I told it, sir. With the director already sanctioned.
Mr. Samantray is not a weak counsel. He is not weak because he is silent. He is just maintaining silence. You are not allowing him to speak.
But my interpretation has gone to 7. I can see disbursement of disbursement.
All right. Dismissal. Next, item 100.
Then my impact will
Yeah.
Yes, sir.
Which,
So we go, so down some time, I will obtain such numbers.
well, you filed this contempt application or filed recently in 2024. Yeah, since I am required to give them opportunity to respond. Yes,
Item 101.
my lord.
My lord, the order that said 31/2024 has not been complied with, my lord. This honorable court has directed to take the decision on the recommendation made by the university for the appointment of the petitioner under the education assistance scheme, my lord, within the period of 2 months, my lord.
but decision has not been taken.
Some time for obtaining. All right, so only item 102.
I mean, pardon your lordship, maybe I made a mistake, your lordship, item number 76. The 4 weeks time, I said that the representation disposal for actually
76.
76.
Please inform it's I'm confused.
One two. Item 102. This is to the staff selection commission in that year.
There is no representation on behalf of the petitioner. Discuss this matter next week.
Item 102.
6/7/23. And of the company annexure 2. I have directed directed to consider reference regarding grant of consent.
Yes, sure, given the property to be found, this one has already been taken with us.
Complied with.
And that other cases, madam,
So far as 4509 is concerned, it's read up in number 1813 of 2024.
First case, man.
Your so far
03, first case is also complied with. Second, after
113. 1510 is. Yes, sir. There, yes, sir. I have instruction because there is no postal value to stand. 4511 loss. Read up in number 2445 of 2024. Then was 4512, it's 2446 years.
Yes.
So the next year 453, it is 2436. 2436 of 2024.
Yes.
Like, item 104. 104 years, I press on sign.
For weeks.
105.
6 to 2024. Bhadrap municipality notice was directed to regularize from the date of rumors and to consider the information, but not that means. Bhadrap municipality, non-government. Not execution, Bhadrap municipality is the content.
You should notice. I have to get notice.
106.
And order that the 21st of June 2023 has not been complied with by the weather opposite party member. And the direction was
Order has been complied, order has been passed for eviction, appeal has been preferred by the other side, appeal is pending by the 107.
non-compliance with the order in the annexure 1 level. Non-compliance with the order in the annexure 1 level. That's a value time for the past interest converts. 4 weeks. Item 108. 108 also was same thing for which time we will 4 weeks. 109. 109. Non-compliance with the order 22/6/2023 lessons. Yes, order has been passed, it has been communicated to the petitioner. Several copy of my friend was order has been passed on 30/10/2023. I've given a copy to my friend. On that one.
This is alleging the non-compliance of the order 21/8/2023. The order was to consider the case of the petitioner election.
Order has been passed, yes.
Complied with.
Obliged, Your Worship.
111.
111 Your Lordship, it was not per se a simplicity direction to disprove the representation, Your Lordship. It was the order of the petition was allowed, Your Lordship, as per the observation and direction of a judgment that was similar in nature, Your Lordship. So the direction was to grant the immediate support to the petitioner.
Let me see.
It has been done, yes, sir. Sanction has been executed. Revision has been made,
And the order was.
Obliged, Your Lordship.
Liberty. And 112. The payment was attendant of the awareness of the judgments.
Was preferred SLP by the SLP diary number 26/504 of 2024. 26/504 of 2024.
Well, good. Where my past and order commented on past the order is compared to this all of the order condition. Now, assist to the order at annex 1.
And this is on 13.
113. 1 and 3. So in the order sections of regularized after 1/2005, let me see the order. Yes. Post 13/25. Yes, sir. This court directly appoint parties to consider the case of the petitioners for pensioners benefit by permitting the petitioner to submit the pension papers afresh and with the pension papers in proper form are submitted before the concerned authority within the period of 1 month from today. The authority concerns are due well to consider the same and grant pensioners benefits as due and admission to the petitioner within a period of 3 months thereafter, if there is no other legal impediment. And thereafter, decision has been, after submission, decision has been taken. What is the post 24, paragraph 24, madam? We have taken the decisions in the appointed regularly after 1/2005. Paragraph 24, these have already heard. The rule, new rule, it is not applicable. Yes, so whatever decision you have taken, you should have taken in the light of the observations made in paragraph 24. So if you have done it, it's all right. If you have not done, then contempt in matter. The people is again mentioned 2 weeks. Yes, as requested on behalf of the AGA, this is matter on 2 weeks so as to enable him to seek further instruction. 114. Yes, no one appears on behalf of the petitioner. Grant me some time for you so that I can get as requested on behalf of by learned AGA. This matter on 4 weeks. Yes, item 115. 100 also 4 weeks time granted for the first time it has come. 4 weeks. Item 116. 116 all complied with. 117. 117 complied with. I have understood complaint for error. Paragraph 10 of the error matter. The Senator Director, since similar persons have their extended vision, in paragraph 10 of the error matter, first one of the contempt. 116 letter. 117. 117. Number 17. Paragraph 10. Yes, paragraph 10 of the order. Paragraph 10 and 11. So, not to program, not to program, and it's we are going to not to program, consider 300. Yes, so let's say para 11. Yes. There you are also directed for the para 11. Yeah. However, the method is reminded that to the operative category 1 to consider the case of petitioner first by taking into consider law laid down in Ravindranath Samal's case. And that's the purpose of Bhavan's question. That Ravindranath Samal case has been challenged in unit appeal. And according that has been stated for the service that we have taken a decision that has been challenging some person and I just repeat my last member that we are the employees of job contract employees, work employees. Where some laptop in that not supervision case that the rule 18 of pension rules was not taken into account, that was dismissed because only export in essence on the ground of limitation. Some similar matters that like there is some other matters that challenging the appeals. Some matters were also dismissed on the ground of limitation. Those matters were approved because the export will stay granted, and in some cases we also granted stay. Since that Devendra Samal case is subject before this honorable court, so no pension can remember the matter to consider the actress in accordance with Devendra Samal case. And
the disobedience of an order of this one. Some of them also order of this court. Dated so and so faster. WPC number so and so. By this order, single judge has directed consideration of the petitioner's case in terms of the law laid down in case of Devendranath Samal. What is the date of the order? That Devendranath Samal. Devendranath Samal, do you have the date of the order? Devendranath Samal. Devendranath, and must be there. Devendranath Samal. Orissa, bracketed WPC number 21 and Narsu Pradhan versus State of Orissa. Reported. Not reported. Orissa in WPC number? Narsu Pradhan or like Devendra Pradhan? Narsu Pradhan. Narsu Pradhan is WA. No, that is WPC because that order of tribunal. Order of the tribunal is challenging WPOC number. The order of the WPC. What is the WPC? WPC number? I am giving that number. It is stated by AGA that the order passed in case of Devendranath Samal is under challenge before a division bench of this court in a writ appeal, which is pending, and an interim order has been granted. Interim order has been granted. That is pending that I have stated that 1/6/2024. He has further submitted that the legal issue involved in Narsu Pradhan's case is pending adjudication before the Supreme Court on an SLP preferred by the state of Odisha. But dismissed on the ground of limitation. Narsu Pradhan was dismissed, but the issue which is involved is second adjudication. Wherein an interim order has also been granted. Though the SLP preferred in the case arising out of Narsu Pradhan has been dismissed for default. We will stop. Next, considering the circumstance that the issue involved in Devendranath Samal and Narsu Pradhan, Supra, pending adjudication, in my opinion, no case of deliberate disobedience of this court's order can be without stop. Contempt proceeding is accordingly dropped. Yes, Yes, that liberty that goes without saying. See, as on date, they have not committed contempt. After disposal of SLP, they may not be committing contempt soon thereafter. So you have to wait for some time for them to commit contempt, and then there is contempt, then file contempt.
Similar passed in Sri Lanka, 142, 143, 142, 142, 133, and 209. 209. 209. Some cases I want, if not pressing my lord. Serial number 134, not pressed. Serial number 197, not pressed. Serial number 198, not pressed. Thank you. Yes. 182. No. On the attempt to do after the adjournment number. And that the Mr. Bubi Rajway. Yes, you are for the contender. No, it's a I am not. All right. I will question on behalf of the petitioner. This is matter on 4 weeks. Yes. Item 119. Order complied. Complied. 120. Complied. 122.
2022 has not been complied with.
Yes. On the table is board of secondary education. Board of secondary education. Board of secondary. Let me see the nature of the order. There is no standing council for the board of secondary education. There are no standing council. So there are only councils are, federal councils are there. Someone is there for the, maybe officer from the state of, SSR, Mr. SSR, senior counsel at least from the board of secondary education. On the 22. The rate of is filed in that case. The rate of appeal has been referred. Are you the officer from the state government? Is he officer from the police come? Please come here. You can convey to your chief secretary that we are facing difficulties in taking up cases which are against the development authority, the CDA, BDA, and other municipal corporations because they don't have any standing counsel. So if they have standing counsel, then it will be easier for the court. Otherwise, in each and every case, the notices will have to go and then wait for service of notices. So if a policy decision is taken, then the functioning will become more smooth. So let it be conveyed to the chief secretary. Yes. 122. Yes, 330. 123. 123 is pending against that order. So we cannot proceed with the contempt. 123. Complied. Complied. 124. 124 and the order dated 31/7/2023 has not been complied, madam. Yes. Municipal corporation, other municipality, Silver municipality, Silver municipality. All right, you should notice. Just a minute, just a minute. Just a minute, very good order. Post 10 madam. And still 115% is post 10 madam. Paragraph 8. 124 is. Annexure 1. Annexure 1. Operating person is first 10 madam. Paragraph 8 madam. Yes. Sorry, no contempt is allowed. This is the present contempt application has been filed. Alleging disobedience of an order dated 31/7/2023, passed in WPC number 23520 of 2023. So it is apparent that the
petitioner has alleged disobedience of the order. The petitioner alleged reliance against opposite party number 4 and 5. 4 and 5. Suppose 4 and 5. 4 and 5. No? 15 number. No. 4 and 5. 4 and 5. We are not noticed while passing the order dated number 6 before number 6 number 6 who has illegally Mr. The person who had encroached the public road, he was not noticed. The authority who were required to remove the encroachment, they were not noticed. And you are urging contempt. How can they commit contempt of something while disposing of the case, my lord? And the direction to the municipal authority of the person. Sorry, they required to be heard. Disobedience of this court's order by the officials of Chandwar municipality. So the municipality was not noticed because of the since the order was passed without in the absence of the municipality, no case of disobedience is made out against the concerned opposite parties. The present contempt proceeding is dropped accordingly. 125. 128 has been some time. Let's come for 126. 126 will be maybe to feel 127 also. 127. Yes. 128. Other which has not been complied with is the side. Private individuals. Private. Private. Resident and secretary of society election. Of the society, sorry. Whether they were noticed, yes, election. It was a contested matter. It was, where is the order? Order election is under Annexure 1. Starting from page 10 election. Annexure 1 was passed on the very same day. Urgency in the matter was there, election. The fact of the matter, if I may be permitted, order is against the refusal of order 39 petition. Wherein in the suit, the suspension of the life member of the said society was under challenge election. And so the matter is pending. The suit is pending election. But in the paragraph 40 of the order may be produced election. There are two operating portions of the said order. If I may be permitted at first place paragraph election. Paragraph 15, 13, 1 3 election. Yes. It, however, appears that there being no express power under the constitution of the society to suspend any life member, this court is of the considered opinion that in removal of the name of the petitioner from life membership of the society, he should be permitted to exercise his right as a life member. This opinion is of course prima facie in nature and is subject to the submission of learned counsel for the parties before the learned trial court. So the prima facie view is that the petitioner should be permitted to exercise his right as a life member. So in the subsequent non-action, for is not permitted to participate in the meeting.
That is my full grievance, Your Lordship. And rather, said opposite that is not side of the matter, stating that this part of the portion of the other is an admitted. This is the operating portion. Your Lordship. So also, they have stopped the remuneration that was attached to the life membership of the petitioner. So basically, they have prejudged the trial, Your Lordship. So even if the suit is pending, the petitioner is
That's everything in this before the trial court.
But Your Lordship, the permitted to exercise his power as a life member, Your Lordship. I'm not sure who what is perished.
This court's order dated 10/4/2024, passed in CMP number 350 of 2024. So, when counsel appearing on behalf of the petitioner has specifically drawn my attention to paragraph 13 of the said order, wherein when single judge, wherein a coordinate bench of this court observed as under it, however, appears that so after having observed as noted above, when single judge clarified that the said opinion was prima facie in nature and was subject to the submission, and counsel for the parties may make before the land trial court. So the said PMC arises out of suit. Civil suit number, civil suit number P10 of 2024, which is pending before the senior civil judge first court Cuttack. Stop. When counsel appearing on behalf of the petitioner has argued that despite the observation made in paragraph number 3, the petitioner is not being permitted to exercise his right as a life member. So, next, in view of the clarification made in the said order itself, that was a prima facie opinion and subject to submission which may be advanced before the trial court on no case of intentional disobedience of this court's order is allowed. The contempt proceeding will drop. Yes, next. Number 129.
No, please, Your Lordship. The contempt of the law, because contempt is the principle of the charge, and so it's one of the fundamental president of the governing body. But college is just the federal education institution law.
Let me see the order first.
Lordship takes 10. That is the order dated 22nd February 2024. Well, there is the order, page 11, the relevant portion, page 11. The order has been put, this is order passed by the 11th director, High Education Department.
No, whatever the direction, that's is 12.
Stat 6. Executive Loan Council appealing for the approval submitted to the subsequent development. The second course is created with effect from order dated 14th February 2023. 13 and 6 shall be given effect. You will not be displayed of considered by both council and the respective parties. It is needless to say that the effect of the order dated 14th February 2023 shall be considered by the occupant of 3 and 2 in its due perspective. They have not allowed you to join in the second course, the governing body.
We are not there. No, discuss to. So notice.
130. So, I think it's 520 was happening compared to the 14th and the petition of the order versus what the order.
Where is
Over the project party number 2, with the respect to officer in charge. Yes. Okay, this is the SP. But this contempt petition deserves to be dismissed with cost. So what is your allegation? My allegation that I like to say, with respect to the thought, probably that is something that said, technology active persons or not active. I was how much? 15 lakhs. 15 lakhs. So we will have to pay 7.5 for filing this contempt application. The petitioner has alleged disobedience of his court dated 5/10/2023, passed in 515 of 2023. Don't dare filing these applications. You file an FIR, then you file a writ petition seeking direction to conclude the investigation, and thereafter you filing a contempt application that the investigation is not being completed. So are we submitting the police or DIG? Council of hearing on behalf of the petitioner seeks permission to withdraw this contempt application. This contempt application is accordingly dismissed as withdrawn. 131. Hello, complaint. 132. 133. My submission is the order is the constitutional order in process. After hearing the topics, not answer the constitutional order in process. And now they are trying to be on communication matter. And that's what communication matter. They are giving the person time to paragraph. Not maintainable. Yeah, I don't have to paragraph 5. So within the content, it's squarely covered and according to directly to the pension, family pension. And they are held it. And the paragraph 4 and 5. So what is the my intent? I'm still appearing at that time I have seen that. I have seen that he has contended that his claim is clearly covered by the decision so and so. This is a case regarding that family concern as per the policy of the government, he is not entitled to. So accordingly, we have filed a repeat challenge with this instruction. May I submit that with my learned friend will argue that I will file a member to that that will be decided in the next week. So that matter will be decided. After 134. Also comes to page 18. 134 order compliance. Direction referring statement and compliance. Yes. Mr. Liberty. Item 135. In 135, instruction read of you filed in course of the government. Similar matter, my change to 18 government. Do you know? In similar matter, that's a process. Where now, so what have I done? So I have to instruction whether was compared on that. Similar matter. Similar matter. Exactly the similar. Sure. I'm the person. All right.
maybe
6 weeks.
every level to get 8 to 11. 8 to 11.
All right. Just a sec. You matter along with
8 to 11. Madam.
Item 136.
Just a moment. Complete.
yes, compared with
137. No. I mean, kindly see the order of the clerk, which we have not been complied page 11. The operative board. Now, which have been confirming read the criminal. Paragraph 9.
yeah, rules for the other side.
No, no, push to your mind.
Huh?
State selection board, Odisha police.
Odisha. Issue notice. Yes.
My Lenin similar is also appearing under the content field, activity cannot be. In the commandant officer.
Accept notice. Issue notice. When so accept, we accept notice on who we are.
Just to be one, so SLP. No, SLP is pending.
SLP is pending.
Kindly provide the number. Diary number 311. 31 of 2024.
SLP pending.
138.
Contempt. Let me see. You may, your application may become better after I go through your application.
Well, luckily have a glance to program number 11.
Yes.
In terms of the data application,
Which is the order which has been violated?
actual value of the order passed on 25th January 2011. Account of the petitioner
And that is pending, is still pending.
that manner I am submitting. In the meantime, I got retired. Happening to the available superannuation. The fact is the account.
Sir, please appreciate this, that I cannot go into such details. And I have to see the order. First, the order was passed in 2011. Your contempt application in 2024 cannot be entertained.
Because of smaller, the bank deducted arbitrarily rupees 7 lakh from my account. That is wrong. So that you may have some different remedy, but not in contempt. The order is the fact that loan deduction shall be done, that is the deducted. All the happen supervision when. That is my lord. 6/6/2024. From my privilege. And we will pending WTC.
So the inside.
Top, the content of the bank, then.
So this WTC number should be taken up.
Let us,
Why do you do this? There was an interim order.
let us have the copy of the copy.
Yes. Notice.
Why do you have? With respect to the month of October, managed for hearing. With respect to the month of October, for reporting. Counterability has been filed. Yes. Before that, 30 months 6 million.
With this contempt application along with WPC number 228 of 2011.
The copy of the contempt application,
With the copy of the contempt application is served upon Mr.
we can sign.
Sorry.
139.
This is regarding non-compliance of the order dated 17/10/2023, part with petition number 31,080 of 2023. Lordship, I kindly come to page 5.
9.
Page 5. 5 of the contempt petition. I have printed the entire order. Where below page 6 it concludes like that. Last word 7, 8 line. With the direction that if any final assessment has been made in time, the funds shall be communicated to enable to file appeal under section 127 of the Electricity Act and making statutory deposit for final one for filing such appeal. Power supply to the premises of the petitioners and the restored. Issue of the secretary. My lord, I have strictly complied with, I have filed appeal, I have made statutory deposit. Despite my failing appeal and making the statutory deposit in compliance with this under the court's order, part compliance which was obligatory on the part of the containers to restore the supply line has not yet been supplied with. Well, the sole grievance is that it's an urgent service lord or a household. And the electricity supply got been despite the clear order.
So what should the appearance you have the replaceable supplier? You have copy of the contributions and the urgent instructions in the same?
Yes, my lord, I will supply that.
Yes.
Yes, so much.
So simple matter,
Simple solutions. Will get in the instructions.
so accepts notice on behalf of, issue notice, so accepts notice on behalf of. Mr. Stays on 2 weeks. So as to enable the council for the opposite parties to seek instructions and file so-called reply.
140. No, 140 first item is complete with mail. It was not possible. They completed our file already.
Okay.
Second item is complete with mail. Second item not complete.
Northwest, complied means which was taken. Compliant with liberty. Liberty you want in a second. You pass the rejection.
It has never run some time.
How many things do you carry every day? There are lawyers in Patna also who used to carry so many pens. All right. Yes.
Huh? 141. No, run some time. For the other.
He's seeking times. Yes.
Weeks.
Huh?
2 weeks.
2 weeks.
Item 145. 145 million complied with.
Compliant.
146. Non-compliant orders. Country central return is filed.
Rate of appeal, Mr.
147.
Compliant with.
Compliant. I have not been given hour. They have been directed to issue the hour. You have deposited the amount. That is the deposit. Without depositing, how the RR will be issued. The last receipt, I have filed the receipt of deposits. Annexure 12, annexure 3, page 12. I have already deposited the money. I have already deposited. I have deposited, it is on that. Yes, madam, there is a direction to deposit from amount, madam. Yes, I have asked.
He said he has deposited. Please seek instructions.
Then I'll take instruction, madam.
Seek instruction because he is saying that the amount has already been deposited.
Now, pursuant to the direction of this Honorable Court, my lord, the amount is already modified and the revision order is put, my lord. Passed. My lord, this is the order passed by the High Court, my lord, this and the revision order is passed, my lord, the documents are passed in 26 for 2024, my lord. So after 26 for 2024, you have deposited. That was the direction. Once the council, this order was passed when? When was this order passed? So, High Court 2023. That was passed by this court. This court. Thereafter, when was the order passed? Later. After no order has been passed by any authority. Order passed? Conversion fees, and I have deposited the conversion. When was the order passed? That order is not within my knowledge, but it is I already just now handed over. 26 for 2024. So after 26 for 2024, you have deposited the amount. Yes, yes. After that, 25 for 2024. And this order is dated 26 May. Taken up the case record today, the petitioner had submitted the receipt of payment after depositing liquidated government fees. That is all right. Then the RP is directed to change the question of Khata, plot number circumstance, from Saturday to Hardin. Yes. This is that. Initially, was filed. So further you will see in that conversion case, when conversion petition will allow, the procedural will not acting further. All right. You see the smell. Who signs allowed for allowed to run AG to seize further instructions. 148. Ransom time. Please. Smile. Oh, 148. 148. All right. 149. We've got already dismissal themselves. 2 weeks. 139. No, ransom time I'll do instruction. 2 weeks. 150. 50 million complied with. That's not granted liberty. Mentioned that only that they are not accepted. Well, actually, 2025 order. They have the order. After your last parents, 24/9/2024, the right to enter to this petition are often 9 months, madam. Sitting over this order.